My lord, item number 13, my lord, 1 3. I'm praying the same to be taken up after vacation, my lord. 13, 1 3. I have taken consent from the respondents, madam.
What's your date maybe?
Dates should go to first week of February. No, December dates are over. We can have it on the 3rd or 4th. The request of the Learned Council for the petitioner, not objected to by the Learned Council appearing for the respondents. Place this matter again on the 3rd of February.
Obliged.
May I please, Your Lordship? Lordship, I'm praying for listing of a regular bill application tomorrow, Lordship.
Senior bench আছে নাকি ওকে? আছে. There's a senior bench.
Lordship,
You
this is
mentioned
below
it.
7 years. Lordship is taking up that bench.
Huh?
Punishment is below 7 years.
Below 7 years to muta. এরকমটা আছে. আছে না below 7 years? হ্যাঁ. Court number 22. Same roster. Yes.
May I beg to mention item 41?
41. Yes.
Hey, R.P. Sharma, sir, senior counsel. He is under some medical condition.
Okay. At the request of the Learned Council appearing for the appellant, list this matter again on
January 20.
January. It's done. January 30 we can give you. 3030. 30th of January.
Lordship, item number 47 of supplementary list.
47.
My lord will like
Yes.
pick it up, my lord.
Oh. List this before any other bench without me.
Oh, Lordship.
May I please, Lordship? I
Yes.
just mentioned for listing one BA Miller tomorrow.
For 22.
422 mention করে
22. Yeah.
Mentioning there
Wait,
for
Mr.
listing.
Lordship. Lordship, I beg to mention for listing on IA for correction of your lordship order.
My order. Okay.
Tomorrow, my lord.
Tomorrow is.
Only, my lord, I am just filing, my lord. After some time, I will give serial number.
Kindly allow me to withdraw item 35, Lordship. The person has been
35.
arrested, Lordship.
When the counsel for the petitioner submits that he is under instructions to withdraw this AB.
Was arrested, Lordship.
With the prayer to approach the competent court for regular bail. AB is closed with liberty as prayed for.
Much obliged.
May I please, Your Lordship? I beg to mention item number 30, Lordship, 30. So I believe today also the case diary is not here, Lordship. On several occasions, the case diary, we got the interim in the month of June, Lordship. So, but the case diary is not here.
The
Once
interim
case-
was granted in the month of June.
Lordship. But once the case diary was here, order also reflected to retain the case diary, but subsequently it was not there.
Let the matter reach, we'll see. What is the allegation maybe? I do not know. Short date at this juncture is not possible. It has to go on 30th of June or 28th. 28 is the earliest. It has been submitted that the case diary in the matter has not been received. The petitioner is on interim protection. This is matter again on 28th of January 2026. The learned APP shall procure the updated case diary in the meantime. Interim order passed earlier continues.
Deeply obliged.
Supplementary list. Delivery of government. Item number. Criminal appeal. 24.
The accused is convicted under provisions of section 304A of the IPC. Conviction awarded by the London Trial Court stands modified accordingly. Accused has already undergone the maximum sentence prescribed for the aforesaid provision. In view of the above, no further sentencing is called for. Criminal appeal disposed of, sent back the trial court records, issue release orders.
Yeah, please, Your Lordship. It's
Yes.
a charge sheeted case, Lordship.
Huh?
It's a charge sheeted case,
Ah.
Lordship. And the accused has been in custody 28/7, Lordship.
What is the quantity?
Commercial quantity, Lordship.
Heard Mr. So and counsel appearing for the petitioner also heard current APP. Give the details. Application under 483 in DPS. Call for the scan copy of the trial court records. List again on 27th of January 2026.
May please, Your Lordship. It's a charge sheeted case, Lordship. 21C is there, Lordship. Lordship, I kindly call for a scan to TCI along with the CD.
Same order, huh? Yes.
Obliged.
No. List again on, you put it on 30th of January.
Item 3.
30. Yes.
May I please, Your Lordship?
Hmm.
So with the clear case of misuse of the POCSO provision, my lord, will please to find the FIR at page 11, my lord. So may I read, my lord? At page 11.
Hmm.
With due respect, I humbly
With,
submit that I,
by omitting the necessary part, please read that. Omitting the names and everything.
my lord.
Do not read out the names or anything.
Yes,
just
yes, definitely, my lord.
yes.
With due respect, I humbly submit that I am a permanent resident of ward number so-and-so, Goliathi so-and-so. My minor daughter so-and-so had been staying at the house of Zolika Burman, a resident of Birkusi so-and-so, since the month of April this year for the purpose of her study. My elder sister's son, so-and-so, son of so-and-so, 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 and my elder brother's, Commissioner Thakuria's son, so-and-so, under Tihu police station, district Nalbari, have been sexually assaulted.
We read it. Aunt's house, both the uncles, huh? Then
Yes. Right now, I'm not going for the merits because sitting will be required, my lord. Before that, my lord, may peruse the page 23. Accused petitioner's BA exam first semester has been scheduled from today, my lord. So for that, interim protection may be granted, my lord.
it
And
has started.
is he will miss this today's exam, but he can sit for the other exam itself.
Which are the exams that he's going to take?
23. Page 23.
Yes, which are the exams? All of these papers he is not appearing.
No,
Which are the
from
papers?
today, from 18.
From 18 he has one paper. Then next?
Next on 20, 22, 26, 29, and 30.
All these. He's
Yes.
appearing in all these papers.
Yes, my lord. It's major. It's minor one, principles of education. Next, principles of education, minor two. Next, alternative English, environmental studies, humanities.
Okay, notice has to go to the respondent number to the
Definitely, my
informant,
lord.
and in the interim, the petitioner may be taken for to sit in the examinations. Huh? He'll be taken there, he'll be brought back.
And my lord, one more submission, my lord,
Hmm.
regarding the petitioner number 2, my lord. He has an infant, my lord, of only 6 years, 6 months old. So he needs also,
The infant would be with the mother.
my lord.
Infant would be with the mother. He's
Infant,
not a widower, is he?
no, definitely,
So we'll have it when the informant appears and the
my lord. Can it be immediately
State
after vacation, my lord?
not very immediately after the vacation. We can give you the earliest possible date is
Already it's 30 days they have been languishing in jail.
around at best it can be 8th.
My lord.
We'll try, huh? 8? Yes, Mr. Swenso also heard. Learned APP. Praying for regular bail in connection with Nunmati PS case number 213 of Swenso, page 2, huh? The Learned Counsel for the petitioner submits that issue notice to the respondent number 2, petitioner to take steps according to the prevalent notification. It has been stated that the petitioner number 1 is scheduled to appear in the BA final examinations.
First semester examination.
BA first semester examinations, which are commencing from today. Huh? Which
It's
are com-
commencing from
no,
16.
which has commenced from 16th, and he has to appear in the examination scheduled today on 2020 12 2025 22 12 26 12 29 12 and 30 12 2025 full stop. The Learned Counsel for the petitioner prays that this court may consider allowing him to appear in the examinations under such conditions as may be required, full stop. The aforesaid prayer is not objected to by the learned APP. In that view, the concerned authorities who have custody of the petition number 1 shall arrange for the petitioner to appear in the examinations aforesaid on 20, 22, 26, 29 and 30.
My lord, if they can arrange, it is scheduled on 1:30 p.m. So if today also they can arrange. my lord.
Stop. What did you say? 30/12/2025. Full stop. The Learned Counsel for the petitioner has also submitted that the exam today is scheduled at 1:30 p.m. Full stop. If it is possible and if it is possible, comma, this court expects the authorities having custody to arrange for the petitioner to appear in today's examination also. We'll stop. List again on what did
Eight.
we say?
8, my lord.
8th of January 2026. By which time the learned APP shall have the service report and the case diary called for. Huh? That'll do.
Okay.
We'll try today also. Kivi, if you can type out the order now. Huh? When
Much
I'm
obliged,
going through other matters, type out the order. If required, I'll sign it here itself.
Much obliged, my lord.
Yes. अच्छा उसमें लिखिएगा that the petition number 1 while appearing it is provided that while when the petitioner is allowed to appear for the examinations, he shall not contact any person. He shall be allowed only to appear in the examinations without contacting or distracting himself. Yes.
Much obliged, my lord.
Yes, madam.
483 application lordship,
Ah.
petition in jail lordship. Page 8 is the FIR lordship. But nothing is lordship.
What is the comment?
Lordship,
Can we have the comment?
page 12.
Page 12.
I have the original.
14, 15, 16.
No issues. We can read 12 also.
Lordship, the petitioner lordship,
Huh?
petitioner lordship, he has a cardiac arrest lordship. I have annexed the medical documents also. Annex the 3 lordship, page 19. Already arrested lordship, and lordship, 60 days holidays also day lordship.
Is the age of the person 44 years? Where is the cardiac arrest part?
Page 19 lordship.
Age 19.
He has diagnosis with acute coronary syndrome and he has severe type of heart attack lordship.
Into 25 medical scheme.
Till page 25, the medical.
Hmm. Hmm. Not intended to incite war or anything, apparently. Have you gone through the language?
Yes.
We'll allow him the interim till the time he's under treatment of the doctors until the CD comes. Once the CD comes, we can see.
He repeatedly doing this type of.
He's doing it
Yes.
repeatedly. We'll make it a condition that he will not be involved in any social media postings. He was arrested when?
This one.
11, 12. Or can we do it this way? We dispose this off. We give you the liberty to come back in case
City may be called for confidential.
you may be called for. Yes. Yes, KV, take down. This petition under 483 has been filed seeking regular bail in connection with Vishwanath PSK, Sariali PS case number so and so. The allegation against the petitioner is that he had uploaded certain Facebook posts which had the capacity to incite violence and disrupt peace because they were targeted at certain high, at certain, they were targeting particular people who wield authority in the state. The petitioner was arrested on 11th of December 2025. On 11th of December.
Yes, it's 11, 12.
Huh?
11, 12.
12.
11, 12, and today's 18, 12.
18, 12. 6 days.
6 days. You see, this medical document cannot come to help because it is after the medical issues that he has been.
Medical ground.
This is 2017 documents.
11, 6, 2017.
This is 2017 documents. Anything more recent? 25, anything of 25 we have? We thought it was immediate.
Lordship, and the Annexer 3, Lordship, he had a heart attack, Lordship.
That was
Yes.
2017. 8
Yes,
years
Lordship.
gone.
And again, Lordship,
Page 25.
the investigation is going on. Page 23, Lordship.
After reopening.
After that,
Immediately on the
regular.
reopening. Na? Oh, we were convinced because of this medical condition. We'll have it immediately on the reopening.
Page 25 to stop.
Lordship, page 25, Lordship.
Page 25. That is also for 2020. What is the date?
Page 25.
Admission date is 2021, madam.
600.
Too far in the day. 6-1, we have got 20 cases already fixed.
Lordship, in that case, interim Lordship.
The interim, yes, interim because he was
Medical ground, Lordship.
medical. We'll ensure that he gets all the medical attention.
Yes,
We'll
Lordship, I have to withdraw the matter because
Huh?
already 15 days, Lordship.
7,
Holiday.
6 days.
6 days.
Yeah, he are repeatedly doing this. Going to the statements.
Not announcing. That part, okay, when it is not targeted at any particular incident or something. Fine.
So,
8.
7 or 8.
Huh?
Dada, 7 is calculation, 7.
Lordship, he wait,
7 or
make
8.
the post.
Huh?
Lordship, he further, Lordship, undertakes that he not makes us post in the social media, Lordship.
We'll produce the case then, after that, Lordship will consider regarding his.
It is too old a matter. What did we say has been suffering from? Arrested on 11th of December 2025 regarding the proceed Facebook posts. Full stop. The learned counsel for the petitioner has submitted that the petitioner is a heart patient who has already undergone angioplasty. Has already undergone. Something case summary who was thrombolized with STK within the window period, and he also has a history suggestive of 2 episodes of angina and angina. The council therefore submits that the petitioner may be released on bail so that he can continue to take the treatment. The counsel for the petitioner also submits that the petitioner would undertake not to indulge in any sort of activities on the social media in whatsoever manner. Stop. The Planet APP has sought for a short accommodation to have the case diary of the regarding the case to be procured. List the matter again on we'll have it at the earliest 8th of January 2026. Stop. Since the ground for medical medical conditions have been asserted by the learned counsel for the petitioner, the court directs the authorities in custody of the petitioner to ensure that he receives all treatment and regular checkups in the meantime. So in case the condition of the petitioner deteriorates for the health condition, they are at liberty to mention the matter even before the next date of listing. List again on 8th. We'll keep it on 8th. If his condition deteriorates in any manner, you let us know. You file you mention the matter. We'll have it on board. Yes.
The regular bail application. Allegation against the
December.
petitioner that they collected money per truck 200 instead of 100. Here's a lot.
Yesterday we had one same matter, 200, 100.
That's it. Page 19. Page 19.
There were people who were not named. We allowed them to appear before the IO and called for the case diary. Yesterday there was one matter, if you can trace out. Maybe we can have it together. Yes, they are named in the FIR.
Yes.
They are named in the FIR.
Page 19. Let's come to page 19.
19 years.
Serial number 5. Truck gari 300, 200, 100.
So by mistake they took 200 when they should have taken 100.
Instead of 100, they took
Taken 200 by mistake.
up to 300. Allow to them collect money.
Well, the 300 would be also with some conditions. Cannot be discretion.
Heavy vehicle truck.
So they collected wrongly. They must have given receipts. Come back on the next day by showing that all the persons from whom you had taken extra money have been returned the money.
Small matter.
No, we have fixed another case.
We have to take.
Yesterday, I'm sure there is another case with the same thing. Those people were not named. Some forget. Yes, so if you can just trace out that case.
I will try to find out.
I will fix the date together so that the CD can be here. We'll consider that and this together.
Okay.
Mr. So-and-so, counsel appearing for the petitioner. Also, praying for regular bail. In Bishwanath Saili case number, page number 1, you will get it. Call for the case diary. List on, you keep it for blank for now. We'll have the date with the other one. Yes. And list along with, that was, if I'm not wrong, an AB. and EB, huh? Keep it
Item
together.
6.
Yes. 6. Yes, sir.
Application for regular bail, 207 days behind the bar. My lord, intermediate quantity of the heroin. My lord, in a similar case, 3 judgment I am placing by our Honorable High Court has granted bail, my lord. 207 days. I will face the trial, my lord.
207
7 days behind the bar.
days. Charge sheet submitted.
Yes.
Charge sheet submitted. Intermediate quantity.
Yes.
After going through the records, page the records.
Huh?
And I will face the trial. Nothing to be investigated, my lord. Investigation is over. I have to now, trial has not yet started. I will face the trial.
What was the quantity found with you?
That is 60 grams, my lord. That is intermediate quantity.
Any money?
No, nothing.
Huh? Any money seized?
No.
No money seized.
Passes have 13,625. Sorry,
13,625.
0625. Then I have already submitted. I have annexed the charge sheet copy also.
The record may be also at this stage.
My lord, what is the use of, my lord, just to detain the matter? For Honorable High Court, three of my lords has considered the similar matter.
You are what? You are usually a what?
I am a businessman,
When you are
my
not a
lord.
trafficker? Huh?
It was not found in my conscious position, my lord, at all.
Where was it found?
It was found, my lord, in a bag, my lord, lying.
Lying where? In your auto rickshaw?
No, my lord, it was, actually, my lord, it was, I was traveling, my lord, then it was found, my lord. I will face the trial, but under any condition, my lord. I will not leave the station. Enough experience, my lord, behind the bar, 207 days.
People to whom these things are supplied spend years in the people to whom these things are supplied,
Yes.
they go for detoxification or something, de-addiction. They spend years, families are destroyed. So that 207 days is not a consideration here.
And quantity doesn't matter in this regard also, in the NDPS case.
That is what was it recovered from? Oh, recovered from his duffel bag.
Yes.
From his duffel bag, conscious position, that is there. Other courts have considered, Mr. Goswami.
That's it.
Other courts have considered on larger amounts
That's it.
and on lesser number of dates.
Detention also. my lord.
The detention has been, yes, sir, in these cases.
Heroin was there.
Heroin.
In other cases also heroin, my lord.
All of these heroin. Charge sheet has been submitted.
Contraband, it is
Huh?
fact. Contraband.
Charge sheet has been submitted.
Yes, I am facing the trial.
We'll put the strictest of the conditions. Huh?
Only thing I want to submit also, the purpose of submitting such sheet is to keep them behind the bars. That is why the mandatory. That is probably not correct, my friend. Yes, sir. I can understand.
90 days was the charge sheet,
Yeah.
it was submitted.
Period of
What
time,
is
we
the
have
stage
35.
now? What is the stage?
Trial has not yet started.
We will keep it on the 5th, sir.
My lord,
We'll keep it on the 5th. Let us see what is the, whether the charges have been
but
fixed or not.
that trial has started, assuming that. But even I am facing it, my lord, and I am not leaving the my lord. My lord, your lordship knows bail is a right.
Kindly appreciate this part also.
No, I appreciate.
We also have,
Offense against society.
we have not even said what to appreciate and you are appreciating it,
It's
sir.
gone for these drugs. Punjab has gone because of the drugs.
Huh.
So, my lord, we
So
want to
what
try
I
to
was
save
tr-
the country by stringent laws, my lord. And my lord, a person who has committed an offense, let him get an opportunity to be rectified, my lord.
what this
Rectified, my lord. If he
what-
is convicted, he will go for 10 years.
what this court is trying to see
Yes.
is the most important factor, that in case the evidence points towards your conviction,
Yes. I will go to
then we are restricted in considering the bail. In
Probably-
case the first few evidences lead us to believe that there may be some scope for your not being convicted or of your innocence, we can consider the bail immediately.
My lord, it
This
is
court is taking much time in considering each of the bail applications.
intermediate quantity. There is no 37 embargo is not there.
Intermediate quantity is not described anywhere. Small quantity, perhaps the person is a addict himself,
What is the bailable? My lord?
and commercial quantity is the person who sells it.
Yes.
There will be something
Well,
in between.
No, that,
We have defined something called an intermediate quantity. I have never find, I did not find that definition anywhere. Anything above the personal use and anything below the quantity stated to be for sale is intermediate. It can be on the higher side, it can be on the lower side. We have got so many different.
coordinate branch has considered the matter.
On the first day.
Yes. Yes.
We would like to have the CD, I don't know.
Then I leave it to your lordship. Because it is the discretion of your lordship, my lord. I cannot, I can only pray.
Understood. Call for the CD list on 5th.
Record, trial court record.
Call for the scanned copy of the trial court records list on the 5th of January. Kindly ensure that the trial court records are here, or it will be done by the registry.
Yeah,
We find one evidence which shows that something may be lenient.
No, my lord.
We are granting it.
No. I appreciate your lordship view. Your
207,
concern with society.
207.
I am also equally because I am a man of society. I know my society.
We have even perhaps made observation that this is perhaps for the own consumption for the next 7 days. We have even gone to that extent.
Yes.
Trying to, but 200
7 days.
grams. And what would it was around how many grams?
61 grams.
Huh?
60 grams, not 61. 60 grams. 60 grams. 60. That's why it's small quantity, intermediate quantity.
We'll have it on the 5th, sir. Huh?
Same matter is AB 298525.
AB 2.
I may be allowed to withdraw, lordship.
Huh?
4, item number 4.
Item number 4 allowed to withdraw. Okay. Ms. Swensol and her counsel appearing for the petitioner has submitted that she has instructions not to press the AB in the present form, and that she may be allowed not to press the bail application in the present form, and that she may be allowed to withdraw with the liberty to approach again. We are allowed. BA is allowed to is closed with liberty as placed for. (27)(1) is
AB 298525.
list along with AB 2985 of 2025 on 27/1/2025. This is for that item number
5.
5, huh? Don't confuse. Yes.
Please, your lordship. My lord, this is a 482 bail petition, lordship. Lordship, FIR is at page 11, lordship. Lordship, the allegation is that, lordship, during the NACA checking, lordship, on 2011-2025, lordship, one truck was seized along with which was, lordship, loaded with suspected battle nuts, lordship, suspected Burmese battle nuts, lordship. And the driver was apprehended, lordship. Driver was one, lordship, Nazrul Islam Ansari, lordship. And it was alleged that, lordship, during the lordship interrogation, lordship, the driver stated that, lordship, we escorted that vehicle, lordship. That was the allegation against us, lordship. But the fact is that, lordship, as per FIR, lordship, that battle nuts was suspected to be stolen, but no one come forward, lordship. And admittedly, Lordship, the learned court below already released that driver, Lordship, Lordship saying that investigation was already completed, Lordship. So, Lordship, we are just intermediary, Lordship.
Where do we find that investigation is completed?
Lordship, I have that order, bail order of
Nice.
the learned court below, Lordship,
So
Which which was on 10/12/2025, Lordship.
we'll allow them to appear if the investigation is complete, if the driver himself is out, the person who could identify everybody. Huh? (2111), this is 10/12, also even no effective investigative entries in the case diary of the IO. Oh. Till 10/12, there was nothing in the case diary.
In a,
Hmm?
in a FIR, it was suspected that it was stolen.
No, this order you can go through. On 10/12, the magistrate records, there is no effective investigative entries in the case diary by the IO. Huh? He'll appear, he'll have his statement recorded. Huh? We are allowing it, we are closing it. Huh? We are
In the
closing
meantime,
this.
call for a case, if anything, it will stand. But otherwise, I have specifically stated that
No, that FIR says that, but investigating
Yes.
nothing.
nothing.
Acha, you take down. Prayer for pre-arrest bail under section 482 in connection with Jirihat PS case number so and so. The petitioners apprehend arrest in connection with the aforesaid case since they have been given the impression that they have been named by the main accused oblique driver of the vehicle in which was suspected to be carrying stolen betel nuts of Burmese origin. Full stop. The learned counsel for the petitioner has submitted that the driver who was driving the vehicle has already been directed to be released on bail by the order dated 10/12/2025 passed by the Judicial Magistrate First Class. Kachar.
Lokhipur Kachar.
Huh?
Lokhipur Kachar, this is a subdivision. MFC Lokhipur Kachar.
Lokhipur Kachar, and therefore he prays that the petitioners may be allowed the privilege of pre-arrest bail. Full stop. They are ready to cooperate with the investigation. Full stop. We had gone through the order passed by the learned magistrate, where there is a reference that the case diary till that time did not contain any effective investigative entries. Full stop. Call for the updated case diary. In the meantime, it is provided that the petitioner shall appear before the investigating officer in the aforementioned case within a period of 5 days from today. In the case of the arrest, the petition shall be released on bail of rupees 15,000. 2 sureties of the like amount subject to the satisfaction of the investigating authority.
My lord,
List again on 6th of February. 6th February.
10 days may kindly be, because actually it should be goes to Kachar Lordship.
Huh?
It should go to Kachar Lordship.
Huh.
So 10 days may kindly be. Within 10 days, we will appear, Lordship.
Who should go to Kachar?
My lord, that order should be
Overnight
goes
train.
to Kachar Lordship.
Overnight train, DTDC, Blue Dart, personal liberty, pre-arrest bail. Don't haggle.
Obliged.
Yes.
Item 8 and 9 arising out of same FIR, Lordship.
Ah.
Page 10 is the FIR, Lordship.
Hmm.
Here, Lordship will find that these present petitioners are not named in the FIR, item number 8, Lordship.
Hmm.
Page 10.
Hmm.
There was dispute between two parties, Lordship, when demarcation was going on, and in between police came. They tried to.
We'll call for the case diary.
No, here they are not named in the FIR.
Then
Lordship.
why are you apprehending arrest?
Because Lordship, we are relative of those named accused, and police repeatedly calling us because they could not arrest the FIR named accused persons. Lordship.
Trace them out, your relatives.
We are in no.
Have you seen the 5th paragraph?
Fifth paragraph, Lordship, may
It
kindly
is
see,
also
Lordship.
to mention. Have you seen the paragraph?
In view of the-
Any leniency at this stage?
So Lordship, may kindly have a look at that. Initially, the discussion with them was cordial. Second paragraph, Lordship.
We'll come to the paragraph later on. Why the FIR? Tell us that.
So initially,
It is to mention during the altercation, one of our lady officers
Lordship.
too was assaulted by the said culprit.
Either sale culprit, that is Suleiman Ali, Rustam Ali, Sohidul. They are not in item number 8, Lordship.
They are not there in item number 8.
No, Lordship.
And what about item number 9?
And item number 9, they are there.
They are there.
That FIR name accused are in
So
item
they
number
are,
9.
so they are all together.
No, not together, Lordship. They are relative because Lordship, petitioner number 1 in the present case is the own brother of that petitioner number 1, Lordship.
What they did as a group?
No, in the FIR itself,
Let us
says,
all
Lordship.
do it lawfully.
No, in the FIR says, Lordship, specifically these 3 persons. Lordship, may kindly, I'm stressing on the word, Lordship, that 3 persons, namely so and so, interfere with lawful exercise of my duty. And Lordship, and that regarding lady officer also, your Lordship will find, it is also mentioned that during the altercation, one of your lady officers so and so too was assaulted by the said culprits. It is not said that, Lordship, in a group they attacked. Others were involved, that is not there in the FIR, Lordship. And it is not said that disputes with the police, it is also not
In
the
item
allegation.
8, FIR is very specific. These 3 persons did it.
Yes.
What about
Their
8?
apprehension is going to the FIR, their apprehension is not necessary at this stage because they were not named in the FIR. If there is not a group, that why their apprehension there?
Why the apprehension?
Only apprehension that the police is calling us to the police station after
When was the last time they called you?
Lordship, that specific date is that I have
Then-
not mentioned, Lordship, but paragraph 6.
They must have
Lordship, may
called you
kindly-
by some person or by the phone.
Paragraph 6, I have mentioned that police also visited their house and asked for their presence at the police station. And this present case is registered and therefore they are apprehending, Lordship. And in fact, that 74, that probably
We will observe in this, in the order, that there is nothing against these in the FIR.
FIR.
And the FIR is specifically related to so and so. So in case the police want to arrest or want to trace them out, should 35 not be followed?
Yes.
35 be followed. In case they receive 35, they come back.
Yeah.
The moment they receive a 35, they come back. And the police will not arrest them without 35. These three. The rest of the 3, we'll have it sometime later.
But Lordship, may kindly see that if 35 is granted, Lordship, that they will appear before the court, but some protection may be there, Lordship.
The
Because
moment they get the 35, let them come before us. We're keeping this pending. We will keep this pending.
Without 35, they will not be arrested. That
Without 35, they will not be arrested because they are not named in the FIR anywhere. That is what we will say. They'll give you a 35, come back immediately.
Lordship. That will do.
But
But
that will not be with regard to?
regarding other things,
That
Lordship, only one
observation will not be there.
Only one submission, Lordship, that is Lordship section 74, which is alleged, Lordship. Section 74 says, Lordship, that if with intent to outrage the modesty, that part is not in the FIR. Lordship will see that only assaulted. Because Lordship,
How do you outrage the modesty of a woman? How do you not outrage the modesty when you have assaulted?
assaulted.
The moment you touch a lady, the modesty is outraged, sir.
No, with intent.
Even my modesty will be outraged if someone touches me. Is it not? Forget about a lady. A man's modesty will be outraged the moment you touch him.
Paragraph 2 is Lordship specific. that
Yes,
there
we are
was-
giving a protection in item 8, and in item 9, we are not giving anything, if we agree to it. This sentence not being there, we would have considered.
Only dispute was individual. That in fact.
Could be,
paragraph
yes. Once there is a uniform, there is nothing to do. Once there is a badge, there is nothing to do.
I leave
It
up
is
to
the
you.
uniform.
I leave it up.
Yes, heard Mr. Swain Council appearing for the petitioners. This is in item 8, The Learned Council for the petitioner has submitted that the petitioners herein are not named in the FIR, and with reference to the FIR, the Learned Council has submitted that it is specifically against 3 persons who had entered into, who had become aggressive, violated the law, and physically attacked certain individuals Moreover, it was those three persons who had assaulted officers, had allegedly assaulted officers during the incident. Full stop. The learned counsel for the petitioner submitted that the police have visited the residential premises of the three petitioners in this anticipatory bail application. How many? Six. Six petitioners in this anticipatory bail petition. Full stop. Keep a call for the case diary. Keeping in view the fact that the FIR is specific to the three persons named therein, and there is no allegation that others had cooperated or joined in, this court is of the opinion that the ends of justice would be served if the investigating authorities are directed not to proceed to arrest the petitioners herein without following the due process of law, namely the provisions of Section 35, with that full stop, stating clear reasons, not full stop, comma, stating clear reasons as to why the arrest of the petitioners herein would be necessary. Full stop. The petitioners would be at liberty to mention this matter before this court in case they receive the notices before the next date fixed. List again on. We will keep it on.
Before Bihu vacation also.
You are protected. You can mention it any day. The moment you receive the 335 notice, you can come back and mention it. Otherwise, we are not burdening the court. Huh?
In item number 9, they will.
Item number 9, we are rejecting, sir.
Lordship may call
30 January 2026. Huh? It will item 8, na? Item 9.
Item 9, Lordship may call for case because Lordship may see that whether it was
Withdraw or dismiss.
so there was
Nothing
actually
else.
there was assault or not, that part Lordship may kindly see. Because Lordship in the FIR your subject matter that 74 is not there. In the FIR first line your Lordship will see subject. But police on the what basis police has registered the case under section 74, that your Lordship will see in the case diary. Because in the subject the informant did not mention.
The case diary will progress once you participate in it. Otherwise, the case diary will be the same. There's
So if other
all these officers, do you think they will retract for a moment?
If Lordship,
They will not
are
retract.
there is the regarding that assault. but that
Anticipatory bail, we are not convinced, sir.
only Lordship may call for case diary, Lordship, that I am not paying for any other relief. Only for case diary, Lordship.
Yes, what do you say, Mr. Goswami? We were not convinced to even half an inch.
Obstruction of the of an
Huh?
activity magistrate.
Have you read the last line?
Yes.
No, the second last paragraph.
Lordship.
It will be highly.
Yes.
We don't want to continue reading it, yes?
Only thing is that they were in possession of the land since 50 years, Lordship. Without their Lordship knowledge, the other side had mutated their land in their name. So they just wanted for some time to get the legal actions, Lordship, against the that person.
We will tell you of a very unfortunate situation today.
Lordship, without Lordship.
No, we will tell you of a very unfortunate situation today. Bulldozers were brought in and the wall was broken. One person who respected the law waited for the opening of the vacation to file a writ petition.
That should have been. But here Lordship will see that
So
initially they
attacking the officers.
So only for case diary I am paying Lordship. Because Lordship, initially there was no dispute with the public officials. It was between the individuals.
The choice is yours, sir.
Only case diary I am paying Lordship. Because Lordship will see that whether there was, because all three may not be involved. That is what I am paying Lordship. Because two persons are before your Lordship.
Mr. Swenson, counsel paying for the petitioner, also heard Mr. Goswami and counsel for this thing. The call for the case diary. List again on what did we give? List again on?
First part of the Lordship.
No, the earlier case, earlier case.
Is there on
21 million. Probably it was
on 31, 301.
301 2026. Stop.
obliged.
10 and 11 is arising out of same FIR.
This one? Oh, acha, another.
10 and 11.
Yes.
Lordship, Lordship will find it is pre-arrest bail, Lordship.
Hmm.
FIR on page 9. I'm
Hmm.
sorry, it was not typed out.
No issues. No issues, it is legible. Application of company records.
Mainly saying that is a company and they have manipulated the 3% has been named in the FIR. They have manipulated the weight of the raw material and the product which is going out.
Hmm.
That is some manipulation has been made. 3% has been named, and this petition number 10 petitioner,
Hmm.
he have a truck hired by the company.
Hmm.
That is why the apprehension police is looking for everyone as the FIR is lost. So he is approached before this honorable court seeking pre-arrest. I cooperate with the RC has, I have annexed already, RC on page.
He is the
annex-
owner.
He is the owner, registered
Owner,
owner of
okay.
a truck. The truck is under the company.
Hmm.
That is, and
11?
Item 11 is a employee of the company of that factory. And he first pointed out the thing that some manipulation has been done by this 3%.
Hmm.
And when the FIR during the inquiry, as the person, the petition number 11 is against the other worker, they have named him. They say that they work under him. This is the allegation as per the FIR.
Mr. Goswami, apparently
Is the,
within a company itself, all records. 10 we can allow because he's the owner of the truck.
No,
He's not in any way related. 11 will give an interim. Let him go before the IO, place all his records, give his statement. If the CD still goes against him, we'll see
Lost.
on the next day. Acha, in this AB 2976, this is an anticipatory bail petition under section 242 of the BNSS praying for grant of pre-arrest bail to the petitioner in connection with BOCO PS case number 368 of 2025 under section Sailobaha, page number 1 or say. The learned counsel for the petitioner has submitted that as per the FIR, there was some manipulation
Lordship.
in the
Raw material.
in weighing the in the weight of the raw materials being utilized by an industry as against the weight of the finished products which were led out of the
Lordship.
company. Full stop. The learned counsel for the petitioner has submitted that the petitioner is the owner of one of the trucks which was used by the company for transportation of their for transportation requirements of the company. Full stop. The learned counsel for the petitioner has submitted that he is not involved in any internal affairs of the company or during the weighing of any of the products or raw material, and therefore, and despite that fact, he apprehends that he may be arrested since his trucks were being used by the company. Full stop. The learned APP has submitted that although no such threat is apparent as of now, however, the participation of the petitioner would be required, may be required during the investigation of the case. In the circumstances above, this court is of the opinion that the petitioner number 2 can be allowed the privilege of a pre-arrest bail in connection with so-and-so case, subject to the condition that he appears before the investigating authority within a period of 7 days from today and has his statement recorded. Subject to, he shall be allowed the record his statement, so and so, so and so, so and so. In the event of the arrest of the petitioner, he shall be released on bail on submitting a bail bond of rupees 10,000 with 2 sureties of the like amount, subject to the satisfaction of the investigating authority. First of bail application, anticipatory bail application disposed of. In the other one,
Other one is the employee of that.
the learned counsel for the.
Discrepancy is present in the stock. He is the storekeeper, store manager.
We'll record all that. Praying for anticipatory bail in connection with so and so. Learned counsel for the petitioner has submitted that the petitioner herein is the storekeeper of the company. Hmm? And it was at his behest, at his instance, that the difference in the weight had been pointed out before the authorities of the company. However, since the culprits had been apprehended and have named him in vengeance
Apprehended, Lordship, during their internal inquiry.
during the internal inquiry, since the culprits had taken his name in vengeance, he apprehends that he may also be arrested in connection with the aforesaid PS case. Full stop. In such view of the matter, this on a call for the case diary list again on. We will have it. Yes, first week of February. First week of February, take a date.
7th of February.
7th of February 2026. It is provided that the petitioner is directed to appear before the investigating officer within a period of 10 days from today to have his statement recorded. In the event of his arrest, he shall be released on bail of rupees 10,000 with two sureties of the like amount, subject to the satisfaction of the investigating officer and on such conditions that the investigating officer may like to impose upon him, such reasonable conditions as the investigating officer may impose upon him to ensure his participation in the investigation process. List as directed above.
Store manager as the designation.
As the store manager, the petitioner was the store manager of the company.
Much obliged, Your Lordship, much obliged.
Yes. Yes.
Wait, Your Lordship, Your Lordship, the affair here is from page 13, Your Lordship. Your Lordship, one young boy, Your Lordship, adopted a young girl, Your Lordship. Your Lordship, thereafter, Your Lordship, his parents and his uncles were implicated in the affair just by sentence that তেওঁলোকৰ কুপৰামৰ্শত লৈ গ'ল. So that is a kidnapping has been.
Where is that sentence?
Your Lordship, you find it in the FIR.
মোৰ ইমান কন্যা ঘৰৰ পৰা স্কুললৈ আহি পুনৰাই ঘৰলৈ উভতি যোৱা নাই, তাৰপিছত খা খবৰ নেদেখুৱা বুলি এখন জাননী অলপ পিছত স্কুলৰ পৰা মই অপহৰণ কৰি লৈ আহিছো. হু ইজ দিছ? অলপ পিছত ইমান নম্বৰ ফোন কৰি কয় যে, to whom does this phone number belong?
Son of the petition number 1 and 2.
Son of the petitioner number 1 and 2. They are the parents. The parents are before us.
The parents and uncle.
You are named in the affair.
Yes, Your Lordship.
প্ৰথম আসামী ঘৰত যাওঁ আৰু ওচৰ চুবুৰীয়া সোধপোছ কৰাত জানিব পাৰিলো যে 2-3-4 নম্বৰ আসামী কুপৰামৰ্শত 1 নম্বৰ আসামীয়ে মোৰ কন্যাক অপহৰণ কৰি লৈ গৈছে. তাৰপিছত আসামীটো মোক বসলি. Where is the lady?
Lordship, I'm not aware, Your Lordship. Your Lordship, again, Your Lordship, while
Half
filing.
knowledge will not help, sir.
Your Lordship, while filing the FIR, Your Lordship, I've not gone through the table, Your Lordship. But here the section suggests, Your Lordship, it is a bailable section, but police.
All?
Yes, 137(2) is a bailable section, Your Lordship, but police is harassing me, Your Lordship.
In bailable sections?
Yes, Your Lordship.
Mr. Goswami, kindly find out. We'll have it at 2.
Your Lordship, if Your Lordship,
We'll have it at 2 if the sections are bailable.
137.
If Mr. Goswami can have some instructions on this, we need not interfere on the judicial level, putting, because if this is done, we'll have to record it.
Lordship.
Perhaps you will have it before 2 o'clock. Kindly have the instructions too.
Let me, Your Lordship. Here, FIR, Your Lordship, will find at page 8. One person, lordship, lost the FIR that from his house at night by some persons entered and committed theft of 3 mobile phones, lordship. That is the FIR. Now, my apprehension is that, lordship, I have received one notice that your lordship will find at page 14.
Is paid to recover the efforts of phones, mobile number, IME number, so and so.
Sorry.
Page 14.
14.
Ah,
I am resident of lordship that Morigaon, lordship,
ah,
and received this notice.
Ah.
The FIR was lodged it at Jurhat, lordship.
ah.
And second line, lordship, may kindly say, first line, one person, namely so-and-so Mohammed.
Bought a stolen phone, huh?
So, in your jurisdiction, bought a stolen Vivo bought a stolen Vivo Y83. So I am purchaser and I have purchased that part I am admitting without knowing that this is a stolen property, lordship. And now I have lordship collected that forwarding report also, page 15 your lordship will get. And actually last line also says similar thing, that accused persons, Gopal Tati, those are the persons who were arrested. They said they have confessed that they have sold and stolen Vivo Y28 mobile phone to one person, namely Sikha so and so.
Oh,
That is different for rupees 1500 and
for
1500
or 2 words before that.
for drugs of value of rupees 1500.
Ah.
Sikha,
Sikha.
not me, lord.
Acha, you are not
Next
Sikha.
line relates to me. They have also confessed that the stolen Vivo Y83 mobile phone was sold to one person, Moirabari so and so.
1,000.
So that is my implication, lordship.
Let him appear with the mobile phone and whatever he has to say. Interim will grant. The Learned Council, এখানে উপর দিয়ে দিব application under section 482 Johat PS case number so and so. The Learned Council for the petitioner has submitted that the petitioner had bought, no, it has been that the petitioner had bought one of the stolen phones involved in the aforesaid FIR, and now he has received a notice to appear before the authorities at the Jorhat police station. Full stop. The Learned Council for the petitioner has submitted that he is ready to appear along with the mobile phone involved and places and have his statement recorded. Full stop. Call for the case diary. Petitioner is directed to appear before the investigating officer within a period of 10 days from today to have his statement recorded. In the case the petitioner is arrested, he shall be released on bail of rupees 15,000. Oh, mobile is of 10,000.
Mobile is of 1,000.
1,000.
1,000.
He bought it at 1,000.
1,000. At page 16.
Furnishing a personal bond of rupees 5,000 to the satisfaction of the investigating officer. From Morigaon, will he need sureties at Jorhat? No, let him be personal bond only. No sureties, huh? Taka, all personal bond kori dio. 5,000, huh?
Must be this period of.
I said call for the CD. I did not fix a date. Oh, I did not fix a date. 7-2. Keep a track of the number of cases. Sometimes this does not get updated. Yes. 44.
May I please, Lord?
Hmm.
The FIS page number 15.
15.
Right.
Yes.
Petitioner is the owner of the said vehicle.
Of that vehicle, which was confiscated in 16th of October 2025. Okay.
Lordship, he has 10 numbers of tracks and all the tracks managed by his manager, Deepjyoti Mili. And after the lodging of the FIR, after seizing the track and with the goods, my lord, till for 1 week, he has no knowledge about the seizing of the track of any case against the track, my lord. Because the manager is his own discretion, he has managed all the tracks and against every track, he has paid monthly stipulated money to the owner.
Hmm.
In the meantime, my lord, on 17/10/2025, the
Mm.
25, the driver was arrested. Driver of the truck was arrested and he was released on bail on 3/11/2025.
Mm.
Thereafter, on 23rd 10, the petitioner came to know that his truck was under police custody. And immediately on 24th, he filed a Jimma petition.
Mm.
I have annexed the Jimma order, my lord,
Mm.
on 24th, 10/2000, on 1/11/2025,
Mm.
page number 19,
Mm.
I had ordered it 1/11/2025. The Jimma of the vehicle was
Allowed.
allowed.
Mm.
When Jimma of the vehicle was granted, the police started to searching me.
Because they wanted to give you the truck, not to arrest you. They want to give you the truck.
My lord, in the meantime,
It is
what
taking up
happened?
a lot of space in the police station. They want you to go and bring the truck.
Lordship, in the meantime, my manager, Deepjyoti Mili, was also arrested, but the lack of the technical difficulties, Lordship, he was produced, but without having any ground of arrest. That's why police, the Honorable Court, learned court below, did not forward to custody, judicial custody. He was granted
He was
bail.
also
Granted
granted bail. Everybody is granted bail. We are disposing it is disposed of. Of Koiribo. In the case of arrest, he shall be released on a bond of rupees 10,000, 2 sureties of the like amount, appear before the IO within a period of 10 days from today. In case of non-appearance, bail will stand retracted.
I'm obliged.
বাকীখিনি মই ভিতৰত দি দিম অলপমান ক্লিক কৰি দিছো Yes, sir.
My lord, in this case,
Huh?
case was posted for mediation, but and directed to release to with the mediation report that is not till today received by the authority.
Mediation
There is
report
the-
not received.
My lord, and mediation of Bishwanath
Not
Sir.
pass any orders until the mediation report comes.
My lord, registry may be directed to call mediation report from Bishwanath.
From
Otherwise, it is
Vishwanath.
yes, my lord. It is directed to produce mediation report on 3rd of September.
The matter was by the order dated
19/6.
19/6/2025. The mediation report was called for. Yes, sir. You want to say something?
Want to reply,
You want to reply to what?
affidavit of additional affidavit.
You want to reply to the additional affidavit. Do you even know that it was referred to mediation? You don't even know. He does not know. Therefore, there is no mediation report
His senior was appeared, my lord, on that day.
before the mediation. In the mediation,
On the last day, my lord. In 19/6, my lord, he said that I have filed an additional affidavit in this criminal petition.
it is between you and Mr. S.C. Biswas.
Yes, my lord.
Mr. S.C. Biswas. Where is Mr. Biswas?
Is another.
You ask him to come. It was a finding correct.
Met legal lordship.
Hmm.
Lordship, we have filed this petition for quashing of criminal proceeding, lordship.
Hmm.
What happened, lordship? The petitioner are the staff of a particular senior madrasa, lordship. Lordship, may kindly peruse page 27 and Annexure 6. Lordship,
If you
what
can
happened?
show us what do you want to be quashed?
Lordship, criminal proceeding of lordship, the cognizance order may kindly be perused, page 62.
Prior to that, we will need to know what is the complaint about.
Lordship, what happened in
Where
the
is that?
page 27 for a moment, lordship.
What is page 43?
43. 43 is the FIR lodged by the present petitioner number
Present
2
petitioner. And what
against the respondent number 2 and
respondent?
others.
What did the respondent initially do? Page 27.
Page 27 is the
Mr.
complete
Providing
page.
midday meal. Yes. Thereafter,
Thereafter, lordship, an FIR was lodged subsequently.
where is that FIR?
Page 32.
Page
Annexure 7.
32. Why do you want it quashed?
Because the misappropriation of midday meal
Ah.
That was the allegation against the headmaster of the senior madrasa, Lordship. Lordship, page 37 is the very relevant, Lordship.
We are just trying to see whether we need to admit it or we need not.
Page 37 is a complaint made against the superintendent of senior madrasa to the inspector of school regarding the misappropriation of midday meal. Lordship, subsequently, page 40 is the inquiry report submitted by the sub-inspector of school, Lordship. May I read, Lordship?
Just a minute.
See,
Page 33 is the FIR which was initially lodged.
Lordship.
And on that is against you.
That is, we filed the petitioner number 1 filed the FIR.
Page 33.
Yes.
Page 33, you had filed the FIR. Thereafter, at page 37, who filed it?
The page 37.
Huh?
Page 37 is the teacher of the school, Lordship.
Against the
Headmaster.
superintendent.
Lordship.
Then what happened?
Then there is the inquiry
By whom?
by sub-inspector of schools, Lordship.
You lodged the FIR before the sub-inspector of
No,
schools?
because of
Okay.
out of that complaint before the inspector of school.
Then
Lordship, may I read, Lordship? The local people, parents of this area, reported me that MDM, midday meal, rarely served during 2017-18 academic year, but the school remained closed since January 20.
Which page are you reading?
40.
41, huh?
40.
40.
Lordship. The headmaster Mohirul Islam was not present on the day of my visit. One day he met me in office and submitted bank statement where 1,31,000 found withdrawn and told me that he recently, March 2022,
He holds it to be correct. Then?
Correct, Lordship.
Then
that report was submitted before the inspector of school, page 42.
Then?
Thereafter, Lordship, as the headmaster was, in the meantime, the school is collapsed because, Lordship, earlier senior madrasa, those were converted into high school, Lordship. Lordship knows it very well. So, school remained closed. And this respondent number 2 and 3, 4 of his brothers constructed, erected house over the land of the madrasa. So, local people gathered and convened a meeting, page 43,
then?
Lordship, then this respondent number 2 and his brothers came to us and they attacked us. So that is why we lost the FIR. But unfortunately, our FIR number is later. Why? Because we lost the FIR in the Fakirganj PS.
What FIR did they lodge?
That is 71 and our one is 73. But the same day, Lordship.
What is this page? 49?
49.
49 is our FIR. I'm for the informant.
You are the informant.
Yes.
You are the brothers of the superintendent.
No, Lordship. There is a completely different story. Our FIR is a completely different story. We are not related to that story.
Let me. That FIR lost by them to counterblast our FIR, Lordship. Our FIR we have lost in Fakirganj PS, the other side of Brahmaputra, mighty Brahmaputra, because of tension. And they have lost their FIR in nearest police outpost. So that is why their FIR registered earlier than that of ours, Lordship. We have already stated in our page 45, Lordship. And there is fear of being attacked in the road to Bandihana outpost to lodge the Azahar, compelled to lodge the Azahar in the Fakirganj PS. Fakirganj is other side of Brahmaputra, Lordship. That is why we lost the FIR on the same day, but later in point of time as per registration of FIR, Lordship. But in
Your
FIR,
allegation is that they came with sticks and weapons and attacked you.
Lordship.
Their allegation is at page 49. 49.
They said that
You misbehaved with the lady.
Yes.
And other assaulted them. Yes.
prior to that, Lordship, may kindly notice
No,
that.
that part we will come to later.
Yeah, Lordship.
You want a quashing of this page 49.
Lordship.
What grounds?
Ground is that the respondent number 2 Now, one point make your lordship clear, page 53,
Huh?
page 53.
Hmm.
That is the representation submitted before the district commissioner.
Huh.
Lordship, may I read, Lordship?
Huh.
With due respect, it is informed that land measuring 2 bighas so and so. So in tier 13 bigha, 15 lesser of land has been recorded and
Tell us, why should the police not investigate into this allegation? Matter is over.
Lordship, why? Because there is the FIR.
Once it
FIR
is
a
investi-
counterblast, Lordship.
Once it is investigated into,
Lordship.
we will know which is a counterblast, whether there is a counterblast or not.
No,
Why should this court
in
retain
the-
the file?
In the meantime,
Ah.
our FIR has been withdrawn.
Why?
Because that
Actually,
case
it
has
has
been
been
withdrawn.
in recorded
pursuant
in page number
to-
63.
Let me finish.
Just a minute. We don't hear two counsels at the same time. We are finding you new here, therefore we are not saying anything. Do not interrupt the conversation.
FIR, actually, why I am coming because the respondent number 2 and his brothers were allowed to erect houses over the plot of land of the madrasa. And that is why, Lordship, they are protecting this adding headmaster, Lordship.
That is all for the investigation and the trial to see.
Lordship,
What is wrong in allowing the investigation? Please tell us.
Lordship, we are the whistleblower. Now we have been roped into this case and we are the first point of time we lost the FIR.
Where is the time?
Lordship,
Ugh.
initial
You
FIR,
did it on your side of the bank. They did it on this side of the bank.
Lordship.
Two different banks.
Page 32 is my
Ah.
initial FIR, Lordship, against the headmaster, Lordship. And this that
That
headmaster,
will take its
Lordship,
own course. That is not connected here.
and Lordship, we have made a representation before the district commissioner that these persons has been allowed by the headmaster to erect their houses over
Sir,
the
you
plot
are
of land.
turning us into an investigating authority. You are turning us into a trial court. You are turning us into everything by asking us to look into this. One simple question: why should we bar investigation into an allegation?
No,
us.
investigation is over, Lordship.
Then?
Now charge sheet has been filed
Ha.
in both cases, Lordship.
Go for the
In
trial.
respect of FIR which we lost, Lordship, that has been withdrawn pursuant to the direction of the government. Now, our FIR and our proceedings remains. Lordship, we have already shown that this.
Yes,
this
government.
FIR is a counterblast, Lordship.
Just a minute. Two FIRs were lodged.
Yes.
One by him saying that petitioners came and assaulted his wife and him. Another by him saying that they came and assaulted him. FIR lodged by him, ended in a charge sheet, withdrawn by the government. No prosecution. FIR lodged by him, allowed to proceed. Almost the same allegation. He says my wife is assaulted. He says my wife is assaulted. Can there be a choice? There can be a discretion. I will withdraw this. I will not withdraw this because of this kind of allegation. Something has to be there from the PP. This is what we took up in another matter also.
And in
It
the
cannot be the choice. It cannot be the choice.
PT cases, comment notification.
Two counter FIRs, one withdrawn.
As per government notification.
That is, please find out.
Whether the same sections are there.
One FIR is at page 43.
Yes.
43 is your FIR. Huh?
Lordship.
So Islam, it is your FIR, no? Page 43. Page 43 says assault came with sticks and weapons, assaulted me so and so, taken away keys from madrasa, Chokidar, Sadat Ali, and locked the madrasas. And the FIR filed by the other person says,
49.
page 49, rebuked my wife, then he assaulted me.
After 73.
If both the FIRs were proceeding, we'd have dismissed the revision now.
But in the case 73, okay. Section 3 imposed on 143, 447, 323 and 506.
Page?
It is page 45, look, this section is
Uh-huh.
typical section is imposed on a section, Polygon PS case number 72.
Just a minute, just a minute. Section?
Section 3, 143,
Ah,
447,
Ah.
323 and 506.
ah,
And another affair, look, other affair. Just 71 of the 22. That section is imposed on 143, 341, 294, 354B, 325 and 379.
mm. So according to you, 49 was not required to be withdrawn.
That should.
Huh?
It's sections where that is different and imposes sections where not that
143, both are 143.
143. Thus 447 is there.
Ah,
447 is there once.
that is not 323, 325. Okay. 379.
29.
379 and 354 are extra.
Extra.
Yes, sir, you have to tell us why.
Lordship, kindly peruse page 63, Lordship. That order, Lordship, passed by the learned magistrate, Lordship. Second last paragraph, Lordship. Perusal of the case records also, and next para, Lordship. I have duly verified the materials on record of this case, and it appears that no cross case is pending in connection with the above case.
Ah. It has to be interfered with. There was a cross case pending. This order has to go. If it proceeds against both. That order is wrong. Do you admit that? There was a cross case pending and the magistrate allowed the withdrawal because there was no cross case pending. There is a cross case pending. Same day, same incident, same place. Is it not? How will we'll dispose it of then? Allowing him to reconsider the entire issue. Before allowing that withdrawal, we'll set aside that withdrawal. We'll proceed against you also. What is this?
Lordship, these first two houses is the madrasa, and second one, next one is the house of the respondent number 2. Lordship. That is why
This
on
is one sentence you had to give us in the beginning of the day, that there are two FIRs
Yes.
allowed to withdraw one because there is no cross case. Matter ends. It's factually wrong. Cross case was there. And then you have to send a copy of this order to the APP who made a false statement to the court. Eh? Yes, I heard Mr. R. Islam Rana counsel paying for the petitioner. I also heard. Or you take the last part of it. We'll record the other part later on. Mr. Islam has drawn attention of this court to the order dated 282023. More specifically, the following paragraphs. Okay? I have marked by this pencil on page 63 up to page 64, A to A. Mr. Islam has submitted that it will be apparent that as on the date of that aforesaid order, there was a cross case pending with regard to the FIR which had been lodged by the
petitioner number 2.
petitioner number
2.
2. Your case was withdrawn by the APP.
No. Which was we lost, that is withdrawn.
That is withdrawn. So there was a cross case which was
By them.
filed by them. So there was as it would be apparent that the cross case in the FIR lodged by the respondent was respondent number 2 was pending in charge sheet state, in the charge sheet stage, full stop. He therefore submits that the order dated 282023 is palpably wrong and is erroneous and needs a reconsideration, full stop. Having gone through the records, this court also finds that as on 282023, there was a cross case pending and therefore the that fact had to be considered by the concerned magistrate before he came to a conclusion with regard to allowing the withdrawal of the case, which arose from the FIR lodged by the petitioner herein, full stop. In view of the above, it is hereby directed, in view of the above, this court interferes with the order dated 282023 to the extent that it allowed the withdrawal of the case which was initiated at the instance of the FIR lodged by the petitioner, full stop. The matter will now be remanded back to the learned judicial magistrate first class Dhubri to reconsider the petition filed by the learned APP by taking into consideration the fact that cross cases existed in the matter. And full stop. The petitioner herein and the respondent will also be given the opportunity to place their arguments when the aforesaid application is put up before the learned judicial magistrate first class for reconsideration, full stop. It is made clear that the learned APP would be at liberty to withdraw the application if it has been filed on factually wrong premise and also to move appropriate application as may be necessary, full stop. Criminal petition disposed of, full stop. Yes.
62 proceeding may kindly be state in the meantime. Page 62 proceeding may kindly the criminal proceeding who is going on.
Which you are facing. No, we are saying both of them will proceed or both of them will be withdrawn. No stay of any proceedings. Your difficulty is you don't have a cross case to implicate him. You are becoming now accused. You want him also to be the accused. In that case, both will proceed. We will not facilitate one.
Decision, your lordship may kindly be stated because otherwise we will have to face the trial. They will
Both
it will
have
take time.
to face the trial after now this order.
That is at a later stage. That is at a later stage. He is saying that in the meantime,
Yes, yes.
his case will go on. He will not be able to do anything. He'll be at a disadvantage. Yes, it is submitted that till the decision on the aforesaid withdrawal application is reconsidered, comma, the proceedings in
Page 62.
proceedings in
ERC case number
ERC case number
3256
3256
of 2022.
of 2022 shall remain in abeyance. Both of you face it.
Item 5, other cases AB, all are in interim. Let's say I'm paying for my cases.
For BA,
Yeah,
for BA, they are persons who were not named in the FIR. You are the person who was named in the FIR.
Small matter, let's say. Fix the matter on first week of January.
First week of January, it's
On-
full. 20 cases per day have been fixed.
On 9th, if possible.
20 cases per day, sir. Fixed. More to come.
Is it 2020, 1920?
Huh? Then there'll be again a confusion regarding on which case the CD has to go.
If possible, 1920.
We can have it fixed on another date. Then your item was item number
5 related.
5. Item number, huh? Oh, एक मिनट. अभी मैं देख रहा हूँ. So item number 5 will fix on 19 we cannot, 20 we cannot, 21, 21st of January.
25.
21st of January. Call for the CD কৰি পেলাই and list along with AB number দিয়া আছিলে তাত. এই AB number টো কাটিব লাগিব. Item number 5 কোনে order টো লৈছিলে মোক মনত পেলাই দিব. হা হা কেভি লৈছিল তো কেভিক কৈ দিব ডেটটো সি ঠিক কৰি দিব মই এবিটো কটাই দিম লিষ্ট এলং উইথ এবিটো মই কটাই দিম আৰু ডেটটো 19 কৰি দিব পাৰিব হা সেইটো কাটি দিব লাগে তাৰমানে নট এলং উইথ দ্য এবিটো 30 তাৰিখে আছে হপায় তেওঁ 19 তাৰিখে লাগে যদি 27 সেইটো কটাই দিব নালাগে এইটো আইটেম 5ত এবি ৰেফাৰেন্সটো আনিব নালাগে
On 20, that's it, 20.
we said 21st
Oh, let's
21st
I'm sorry for interruption. You
No, sir.
also call me, my lord.
Yes, there was some confusion regarding that mediation report.
Let it go, mediation. I have got no problem.
No, there was mediation report has not come. And the person who had appeared here, the counsel who had appeared, he told us that he would like to file an objection. Now, when the matter is on mediation,
They have filed, given this document, which I cannot read even. So ineligible, my lord, your lordship will find. So, my lord, they should give.
English will pass. Mr. Biswas,
Clearly visible.
Mr. Biswas,
Clearly visible document. I am for the.
please
Is it
listen to us.
Yeah.
Listen to us.
Please, please, see.
Mr. Biswas,
Yes.
listen to us. We are requesting you. What we propose to do is we'll call for the mediation report. In the meantime, you want to file an objection, you file an objection to this. The last order said that the persons are aged and it is difficult for them to go for mediation. That was the last order. Therefore, we asked you to come. That was the only reason we wanted you to come. We'll ask for the mediation report. We'll allow you to file the objection. He was wrongly instructed to the extent that he was only telling us we will file objections. To what? When the matter is in mediation.
Furnishing a eligible document.
My lord,
Look at his copy. Look at his.
There is 105 onwards, all illegible. Nothing, no one can read. 100.
Yes, we'll pass. We'll pass all of it. All of
But you
episode
haven't
mati
given
dibo.
him.
All of episode mati dibo.
there na. Type copy is there.
But what is in the translation, I have to see.
It is not translated. It is.
But it is nothing, is 105, 106, 107, 108, 109, not visible, my lord. Not legible, and nothing is there.
That's why.
Anyway, I'll collect from him, my lord. I'll collect from him.
Huh?
I'll
Solved.
collect from my brother.
Yes. Problem solved.
Yeah.
Item number was
14, 14.
14. Item 14 to likhi laksu. Mr. So-and-so appears for the petitioner. Mr. So-and-so appears for the respondent. The mediation report called for has not been received. Registry to issue reminder to the learned mediator to furnish his report as early as possible. Full stop. Respondent would be at liberty to file their objections. Learned counsel for the petitioner has undertaken to supply a legible copy of the entire set. Full stop. List again on when do you want it?
19, my lord.
After
19.
vacation,
19 January.
19 January.
if your lordship permits, man. Because after 21st, your lordship filled up already, I think.
That is what we are full up till 22nd. Can it be 27th
No objection, I've got.
or 28th? Whichever is comfortable to you.
30th, my lord.
Huh?
30th.
30. 30.
Obliged.
On 30 July. On 30 January. এইটো প্ৰিণ্ট আউট কৰি ইণ্ডিয়া এইটো কোনটো এইবোৰ পিছত এইবিলাক নাই সেইটো দিলে হ'ব য়েছ নেক্সট এইটো এতিয়া লৈ আহিবিহে কাৰেকশ্যন কৰি 16 য়েছ মেডাম
Your Lordship, petitioner has expired during the pendency of the.
So what do you want now?
by the family members
Huh?
over phone as
Okay, the learned counsel for the petitioner submitted that she has received telephonic instruction that the petitioner has demised.
like to
Withdraw, not withdraw, huh? And that she's under instructions not to place this petition in its present form, full stop. Accordingly, this criminal appeal is disposed of on withdrawal in its present form. Stop.
Chayanika Burman. Chayanika Burman.
Yes, next. Yeah. 17, no one. All of episode material. All of episode. Yes.
Quashing of criminal proceeding pending before SDJM, my lord.
Why?
What happened this, my lord? On the same sorts of allegation, one FIR was lodged before the Lakipur Police Station 72 of 25, my lord. That was ended with a charge sheet, my lord, against the petition number 1, my lord. And other where, my lord, were not sent for charge sheet. It has no sufficient evidence was found against him, my lord. My lord, kindly have a look, page 31 of the charge sheet, my lord.
What? Where is the first charge sheet?
This is the charge sheet, my lord. What happened on, first of all, 72 of 2025 FIR was lodged before the Lakipur Police Station on the allegation of physical assault, my lord, by the wife, my lord. On the same sorts of, thereafter, my lord, police after completion of the investigation submitted charge sheet, my lord, on 15/7/2025, my lord. After submitting of the charge sheet, my lord, on the same sorts of allegation, my lord, CR case was filed before the SDJM, my lord. My lord, kindly have
Where do we
the
find the allegation? Yes.
my lord, page 11 onwards, my lord.
Just on
This
page
is the PR
30.
case subsequent.
Guardian was filled up. When she took into the house of the son, that her husband and violation with the time of marriage, like his husband related so and so and so. Take talaknama, okay. For sickness, so and so. Accused Abdul so and so and so, married complainant under Islamic rights. Husband conducted cruelty over the complainant wife to harass in coercion. Official well established. But to send you up for trial. So here only the husband was sent up for trial. Huh?
Trial, my lord.
Okay. And now the new, where is the new FIR?
My lord, page 19, my lord.
19.
19 is the earlier FIR, my lord.
We don't need that. We need the new FIR.
New, my lord, page 10, my lord.
Page 10.
Same sorts of allegation, my lord.
The time is Is it under stay?
No, my lord.
Is the second FIR stayed?
No, my lord. Today first time it's before.
Today first time.
My lord.
Mr. Goswami.
Yes, sir.
Page 31. The
Yes.
hence part. Do you find at the last paragraph? Page 31, hence.
Lordship.
That part, and if you go through page 12. Hey, Hari, all of অৰ্ডাৰটো এই BM ডেকাক ফোন কৰি দিয়ক। কোড কৰি দিব নহয়, প্ৰিণ্ট আউট উলিয়াই পেলাই মই যাম সিগনেচাৰ কোড মাষ্টাৰ above order was passed by the লিখি পেলাই লিখিব and is a print out of the from the website লিখি এটা দি দিব তাৰমানে চাৰ্টিফাইড ল'ব লাগিব সি পৰীক্ষা নাপায়গে এটা লগত যদি দি দিব পাৰে পৰীক্ষাটো পাব এতিয়া আপলোড কৰি দিবলৈ ক'ম আপুনি চাৰ্টিফাই কৰি দিব মানে চাৰ্টিফাই নহয় আপুনি চিগনেচাৰ এটা কৰি দিলে হ'ব same thing she just wants the confiscation of the registration form so that can be done by the investigating officer in the other case already charge sheeted there is no problem they can still bring it we are saying this heard Mr. So-and-so learned counsel appearing for the petitioner also heard Mr. Goswami learned counsel appearing learned APP full stop the grievance raised in this petition is that on an earlier FIR filed by the
number 2 by the
respondent number 2 comma the matter was investigated into and a charge sheet was submitted by charge sheet number 77 of 2025 dated 15/7/2025 and the case is now awaiting trial. During the pendency of the aforesaid proceedings, comma, the respondent number 2 has filed another FIR on
my lord
has filed another
CR
case
on
before the learned subdivisional magistrate, which was registered as CR case number 30 of 2025, leveling the same sort of the same set of allegations. Full stop. Issue notice extra copies to the learned APP during the course of the day. Notice on the respondent number 2 by speed post. Having gone through the contents of the CR case and also the copy of the charge sheet as annexed to this petition, comma, this court is of the opinion that the proceedings in CR case number 30 of 2025 is required to be kept in abeyance during the pendency of this criminal petition, full stop, order accordingly. The proceedings in CR case number so-and-so shall remain in abeyance during the pendency of this criminal petition, full stop. List again on the, you go to the second week of February now. On the 10th of February 2026, along with service report on the respondent number 2. We don't need the TCR now, later appear, we'll see. Yes.
SDJM M Lakipur.
CR case number, we have CR case number so pending in the court of the learned SDJM.
M Lakipur Kachar.
Lakipur Kachar. Yes, madam.
Lordship, this is a 528 application, Lordship. I'm praying for the quashing of the entire case of maintenance, which is pending before the SDGM as Dibrugarh, Lordship. Now, both husband and wife, Lordship, they are in lucrative jobs, Lordship. Maintenance is that 144, now BNS is 144, it's a welfare legislation, Lordship, when the woman is not able to support herself. Lordship, in her assessment liabilities.
These are arguments before the court deciding the matter.
Lordship, because this cannot stand the test of law, Lordship. It's an abuse of the process of law. This argument will, because the entire proceeding, the main thing is, Lordship, whether she's capable of maintaining herself or not.
Has to be decided first by the?
No, Lordship, that's why I'm here, Lordship. I have also challenged, whatever. I filed a divorce case. Both stayed in United States. So her condition was like she was like since 2021, we did not have any conjugal relation. We were both like through me, she had done dependent visa, one, and she was having lucrative job in US where she was earning to the tune of crore of rupees till 24 December, Lordship. And in her assessment liabilities also, she has annexed, Lordship, that right now in her bank account, she has nearly 1 crore of rupees. And how can this maintenance they can issue a notice?
While issuing notice,
Lordship, they did not,
the court is required to go through the contents of the complaint
Lordship.
and have its own trial stage. Now that trial stage, apparently from whatever affidavits you are saying has been filed, it would be a matter of no case
No
before
case.
before the family court.
Lordship.
Now, without allowing that,
I understand.
without allowing that court to come to a conclusion, would it be appropriate for us to turn ourselves into that court to decide that issue?
Lordship, the law is very clear. The Supreme Court is very clear with the law. So why and so for my argument's sake, why should I go even for 1 day, Lordship?
We can.
One Lordship, even the DV case, Lordship, the coordinate bench of this honorable court had stayed the matter, even the domestic violence, because it had
The
come
domestic violence is under stay. We don't have a problem in that.
maintenance.
That would be one of the grounds. The moment there is an order of maintenance,
This order till
then we can step in to say that on these grounds we do not see that a maintenance should have been.
no, on the
We are not the court who gives the maintenance,
I
and we do not
understand.
decide whether a maintenance.
Argue on the legal point, Lordship. That is the thing.
We can issue a notice.
And the Lordship stayed proceeding till the next date at least, Lordship.
We would not like to interfere in the functionings of the lower court when they are yet to take a decision. It would be prejudging them.
I understand.
It would be prejudging them.
I understand. But me also had a thought, Lordship, and I went through several judgments, Lordship. The court can
All
interfere.
of them can be decided once the trial court takes a decision. We will look into every aspect of it.
After
Place it before the trial court. You are not required to pay the maintenance on the next day morning. You have a,
Lordship, I might. It's a hefty amount, 65,000 a month.
so it would not be on the next day itself.
No, because it's a
You would still have the chance of an appeal, a petition, a criminal decision, anything you want to do within the next 1 week.
Lordship, actually the matter is fixed on 22nd. This 22nd. That is
For
for appearance.
the appearance has to be there. Your stand has to be before the.
Also last day.
Now for the appearance of whom?
Again, for me only, but to submit my WS. I'm sorry.
So it is for WS, not for appearance.
Lordship.
The WS has to be submitted.
I just pray, Lordship, if I cannot satisfy the court on the next date, I may withdraw it and go to the court.
When do you want it?
Lordship, January 1st week also will do.
It has to go to February, and we are not.
Yeah, Lordship,
We are not inclined to stay it because it will be interfering in the process. We are not seeing why we should stay it.
Lordship, it's Jandu Pharmaceuticals and
When did you appear?
on the last date, Lordship.
When was it?
Remember, I'll supply the last. I appeared, Lordship. Because, Lordship, it's an abuse of the process of law, Lordship.
All this has to be decided by the lower court, madam.
But it will take a long attendance.
Let that affidavit be filed. Let your written statement be on record. Let the court not take into account your written statement. Or let the court not ask for that, that affidavit of assets and liabilities.
No, Lordship.
One wrong step and we will
Yes.
definitely correct it. But without allowing the baby to step, would it be for the father to hold his hand and carry him around in the room? No.
Lordship, because there are several judgments of this.
Second last day before the vacation, people are waiting. It's either a notice.
Yes, notice.
It's only a notice. Heard Ms. Swensel and counsel paying for the petition. You are paying for?
Respondent, my lord.
I think we were issuing notice today.
There are series of litigations. So we have.
No, we are interested in this litigation. From where did you come to know?
So I have instruction over phone to appear.
Any caveat? Nothing. Okay, issue notice to respondent number 2.
No, Lordship, they are appearing. We'll just supply a copy.
Still, the order has to contain the sentence that I am issuing notice to them. Does it not? We would like a lesser interference when we are dictating the order.
Sorry.
Issue notice to respondent number 2. Mr. So-and-so has appeared before this court and submitted that he is under verbal instructions to appear in the matter and would be filing his wakalatnama before the next date of listing. In such circumstances, formal notices are dispensed with. Learned counsel for the petitioner shall supply copy of the criminal petition to Mr. So-and-so, learned counsel appearing for the respondent number 2. List this matter again on the 8th of February 2026, by which time the respondents may file their objections, if any, to the criminal petition.
Only one sole respondent, not.
Any orders passed in the maintenance case will be subject to outcome of the criminal petition.
Actually, sole respondent. Note if this.
The sole respondent, it is not respondent number 2, it is sole respondent. Huh?
Obliged, Lordship.
Obliged, ma'am. My lord, this criminal petition is filed against the judgment and order dated 5/12/25, which upheld the rejection of Jimba of sale proceeds of 90 MT Battle Nut by additional Chief Judicial Magistrate order dated 28/1/23. Fact of the case is that petitioner disbursed 90 MT of metal nut from Jiribam to Shialda, Kolkata on 6/9/21 by rail with valid GST invoices, UAB, and all documents. But when the goods reached in Bodhapur railway station, the GRPS railway police seized the goods and registered a case, and thereafter subsequent auctioned it and deposited to the sales proceed to his to the name of the petitioner. It is at page 104/105. 104/105.
Proceeds were deposited then?
Yes, sir. Yes, my lord. But sir, in the name of the 105. Proceeds were given in Assam Trading and Marketing Company, Assam Trading and Marketing Company, Assam, these things. Now, the rejection of Jimma of sale proceeds of 90 MD Battle Nut is in distinct violation of Article 141 of the Constitution. As the learned court below fails to apply, both these additional Chief Judicial Magistrate and Divisional Court failed to apply the binding law laid down by the Honorable Supreme Court.
Where is the
It is Sundarbai case.
Where is the order passed by the court below?
It is at page 67.
Huh?
Page 67.
67.
Yes. Session court order. 5/12/25.
Just a minute.
Page 67 to 74.
Yes. Yes.
So this has upheld the rejection of Jimma of sales proceeds of 90 MT. This has upheld. This revision court order has upheld the rejection of Jimma of sale proceeds by additional Chief Judicial Magistrate order.
The firm is non-existent is the reason.
My lord.
The firm is not non-existent.
No. That is incorrect, my lord. That is not correct. The firm is that is a consignor. Consignor is Assam Trading, and this is a backdated police report in 2021.
We'll ask for a fresh report.
No. No charge sheet has been given for the last.
Should we ask for a fresh report today? At best, we can ask for a fresh report whether the
Yes,
firm
sir,
exists.
that can be done, but this notice should be issued, my lord, and
But Mr. Swain,
nothing, no charge sheet has been filed, no
money-
final report has been given.
money is one thing which will not become bad if it is stored for 4 years.
No, in this case, Supreme Court says that it should not be.
No, we are issuing notice.
Yes,
We are asking for a fresh police report on the existence of the firm.
Yes.
That will do?
Yes.
Yes, heard Mr. So-and-so, learned counsel assisted by Mr. So-and-so, appearing for the petitioner. Also heard the learned APP. You are appearing, Mr. Gupta? And Mr. H. Gupta for respondent number 2. Goswami for respondent number 3. Who is 1?
Assam, State Assam.
Why do you want respondent number 1 to be a party?
State.
State is representing us.
This is.
This court does not find that the presence of the respondent number 1 is required for adjudication of the matter. Therefore, notices are not being issued to the respondent number 1 at this stage.
2 is Superintendent of Railways. Assam. Guwahati, this.
He's appearing.
Yes, okay.
And 3 he's appearing.
Okay, officer in charge Bodhapur, GRPS.
Since the respondent number 2 and 3 are represented, formal notices are dispensed with. However, extra copies of the petition be supplied to them within by tomorrow. Full stop. The respondent number 2, who will bring it? Respondent number 3. Who will find out the existence of the
This is three, my lord.
the respondent number 3
Yes, lord.
shall file a report or shall make available a report on the next date of listing regarding the existence or otherwise of the petitioner company, comma, which existence was denied in the proceedings before the learned magistrate and the learned session judge. Is it not?
Yeah, man.
Huh?
Planet SCJM, Additional Chief Judicial Magistrate.
Additional Chief Judicial Magistrate and stop.
My lord, 4 years my capital has been blocked. The harassment, my lord, to me.
Full stop. The respondent number 3 shall also clarify the issue of ownership of the original of the betel nut, which was in issue.
All documents I have submitted along with this petition,
List again
as well as
on-
before the lower court and
List again on the 3rd of February. 3rd of February?
after 10th, my lord.
After 10th of February?
Yes, yes.
Then you have it on 12th of
Yes.
February? On the 12th of February 2026.
Much obliged.
Your Lordship,
Yes,
Lordship,
sir.
this is a regular bail application, charge sheeted case, Lordship. 179 days today in jail custody, Lordship. FR that is on page 14, Lordship, case was registered under 376 and 4 of the POCSO. The age of the victim say, Lordship, 16 years, Lordship. Now, Lordship, the victim's evidence already been recorded, Lordship. The TCR is there, Lordship. The cross part, Lordship, she has stated, Lordship, she has not seen the face who has committed such things, Lordship. Otherwise, justice submitted, Lordship, on 25/6/25, Lordship. There are 11 witnesses to be examined, Lordship.
She has not seen the face.
Yes,
That is
Lordship,
the
in
ground
cross
for
parts, he says, it's stated, Lordship.
Where is that?
TCR is there.
Have you seen the TCR?
Is probably PW3.
Minor, there is no issue.
Date of birth is 3/2/2000.
You are the Ghostbuster or the person who has brought him?
Ghostbuster.
He's the Ghostbuster. Applicant, huh?
Cures people from jinn. He cures people from.
That is why I said Ghostbuster. That is what you call a Ghostbuster.
My idea, Lordship, he is more than Ghostbuster.
He creates ghosts. First part. He's saying this evidence has been recorded cross part. Where is it? When did the cross examination take place?
And on 28th of November, ma'am.
28th of November. Unable to find it. I hereby PW1 is the informant.
Yes. Who is the
PW2
doctor?
is the doctor. And PW3. Okay. You said not seen
His face has not seen.
because there was an
light.
arthen lamp lit
Yes.
close to where I was sleeping. I could see the accused face well.
I was waiting for that. Since Lordship on 79 days,
Ah.
Lordship, there are other
We can provide for the materials to be supplied to him. He can try some of his profession inside there. Not this case.
Lordship, let it be kept pending, Lordship.
For what?
Lordship, other evidence, Lordship, regarding Lordship, the age proof, Lordship, whether that.
There are cases where we feel that at some point of time there may be a dilution. And there are some cases we feel should send a message that wholly uncalled for. Heard Mr. Svensson and counsel appearing for the petitioner, also heard learned APP. The trial court records received have been produced. The statement of the minor victim and the two PWs have also been considered. The charges are under the POCSO Act, full stop. Upon going through the statements made, this court is not convinced that there is little or no chance of conviction, full stop. Therefore, at this stage, the prayer for bail of the petitioner is rejected.
Obliged, Lordship.
So and so appears on behalf of the informant. Yes, madam.
Wait, please, your Lordship.
Ah.
Lordship, the accused are in custody 122 days. This is
Ah.
commercial quantity, Lordship. Lordship, the accused number 2 is the lady and she is illness, your Lordship. And I submitted some of the medical documents, your Lordship, of the annexer.
She's a lady having what problem?
Yes, Lordship, she has the problem, your kidney problem and ulcer also.
Yes.
And I have submitted the medical documents, your Lordship.
Copies are not in totality, Lordship, because only the charge sheet is there. We must have the case diary also, Lordship. Scan copy of the case.
Okay, we'll keep that in mind. Yes.
Of them, right?
We'll ask for the case diary today.
Yes, Lordship,
Complete case diary has to be.
48 notice also not communicate to the
records, Lordship.
yes, Lordship, kindly
Communicated to whom?
communicate to the friends or the relatives of the
Who was the friend that you nominated?
oh, Lordship, not to communicated any notice under section 48.
Madam, I want you to give a New Year card to Mr. Sharma's relative, friend, or somebody, family. Kindly tell us whom will you give it to?
Lordship, they are having
Who has to tell you whom to give? He has to tell you.
no any
Please give
notice
it
should
to.
be received, your Lordship.
Huh?
No any notice should be received.
Before that, you have to nominate someone.
No any person, your lordship, not Sasa, no Mama, no any person.
How will he trace out who is the Chacha and the Mama?
Your lordship, where is the constitution mandate, your lordship?
That is what-
Article 22 clause 1 and 20.
Okay,
Yes.
we'll wait for the case diary. We'll wait for the.
I notice under section 48 may be called.
Everything. The learned, heard Miss So-and-so learned counsel appearing for the petitioner, learned APP has submitted that although some scanned copies of the trial court record has been received, comma, it is not complete since only the charge sheet has been sent, full stop. Learned APP has requested that the entire records of the trial court, a scanned copy of the entire records of the trial court would be necessary, full stop. Accordingly, registry to send a reminder to the learned trial court to send the full scanned copy of the trial court records to be placed before this court on the next date of listing. List this matter again on
29th of January.
29 is
29th of January
29th of January is so much long that, your lordship. Kindly 5th January may be fixed.
29th of January. Prior to that, madam, we have filled up the entire case.
Lordship,
Entire diary is filled up.
the-
Next.
Difu code, your lordship.
Huh?
Scan copy and second case
You will have to extend the court timings otherwise. You will have to ask us to sit from 10 to 5.
29 January is so much long that,
It
your
is,
lordship.
we do not have a way out.
Right? 5th of January.
We are trying to have the Bihu vacations cut short. We have made a request to the Supreme Court. We can make a request. Take away the holidays. Cannot do that. We have fixed 20 cases a day up to 27th.
29 January is so much long that because.
Yes, it is.
Ready also.
Next, madam.
Suffering some kind of illness, your lordship.
You-
I have submitted the. legal
The learned counsel for the petitioner has submitted that the
January
petitioner number 1 or 2.
2.
Petition number 2 is suffering from kidney related diseases.
Yes, lordship.
Full stop. The authority having custody of the petition number 2 shall ensure that she does not suffer due to lack of any medical attention for the diseases referred to in the bail application.
And lordship,
Anything-
kindly reflect this, my sentence, your lordship, that 40th notice may be.
The learned counsel for the petitioner has also submitted that the section 48 notice under section provisions of section 48 was not duly served
Yes,
upon the friends, family and relative of the.
yes, lordship.
You must now maintain a,
According to Bihan Kumar
Yes.
judgment, your lordship.
according to the Bihan Kumar judgment.
Yes.
Anything more? ma'am?
Pre-professed. Obliged, sir.
Item 12.
Worship, your lordship has sought for instruction, your lordship. I came to know it is a bailable section has been, your lordship, now your lordship.
The bailable section, lordship, so
Ah.
AB does not lie, lordship.
AB will not lie, but the person has been arrested. He has been remanded. What is going on?
No, arrested, your lordship. I have been searched for.
Oh, you are being searched for.
Yes, your lordship.
I was under the impression that this is a BA.
Lordship, it's not maintainable. lordship.
My apologies, huh? Learned counsel for the.
It's a bailable.
My learned counsel for the petitioner has submitted that although this AB petition had been preferred, comma, on a perusal of the FIR, etc., it has been revealed that all the sections, all the provisions of law mentioned in the FIR are bailable sections, full stop. Therefore, he prays that he may be allowed to withdraw this anticipatory bail petition without prejudice to the right of the petitioners to approach competent forum of law with with any grievances arising out of the FIR. AB is allowed to be withdrawn with the liberty as prayed for.
Some sections will be added later on, lordship, because the.
That is why I said that he will be at liberty to approach against the FIR if any grievance is there.
See, the bailable offense, the police have ample power to give him bail, lordship.
That is what, let him go and do it.
The victim has not been recovered till date, lordship. So some more sections are coming, lordship. That
Ah.
was why I was.
Then he will come back.
Your lordship, I am not the main accused, your lordship. I am the parents.
Then he will come back. Then he will come back. He wants to withdraw it on the present sections which are all bailable.
Amicus may be appointed. Service is complete, I think. Oxford.
Yes, for the service is complete, lordship.
Service complete. Learned APP has submitted that he has instructions that the service on the respondent number 2 is complete. None appears for the appears for the respondent number 2 today. Accordingly, appoint. Act number আছে নেকি কিংবা? Huh? B. Chaudhary, Miss B. Chaudhary, learned counsel as amicus curiae. This is the court. What about the CD, sir?
CD has not been received, Lordship.
When can we have it?
Lordship, it's a BA, Lordship. Only one submission, my lord. On 5th of January, my lord, it will be 90 days, my lord. Then, my lord, on 6th.
On the 6th of 6th, no. 6th will
That will
be
make
the
it
7th.
7th.
We'll have it on 7th.
Fine.
On the 7th of January, since the Learned Council for the petitioner submits, that 90 days would be completed on the 5th of January.
That may not.
That one not to be recorded. List on the 7th of January.
I'm obliged.
Yes. Aye. 21.
Court did application. As per record, the notice, LCR is also been
Not dated
can give
4/12/25.
received, and the
It's not dated 4/12/25.
Received.
notice was
Respondent number 2.
Dated, Lordship.
Service awaited.
No, it is. No, in the file, my friend said that report, notice has already been received by the
Notice has been served, Lordship.
flag Y, no?
Why?
Tag Y.
Kindly mark the receipt of the notice. To deduce. You say the notices have been received. Kindly mark that part, which shows that the notices have been received.
Wrongly.
The notice has been sent, notice, not sharp, notice sent. Anyway, we are in the in custody for last 120 days, and the LCR has been already been received, and as saying that the notice had already been sent by this registry.
Either we have to wait for
immediately opening of the and in the meantime the registry directed to take the fund the report, because the registry send it to the police office.
Registry bringing the report quicker man is he getting an instruction.
High Court now, High Court procedure which adopted High Court, we have to giving all are routed through the
office note dated 4/12/2025 reflects that the service report on respondent number 2 is awaited. This was also recorded in the order dated 8/12/2025. The registry has not updated the note on the has not put an updated report with regard to the service on the respondent number 2. List this matter again on 9th of January 2026. 9/2026, along with the office report on the service of notice on the respondent number 2.
Yeah, please, Your Lordship. Lordship, this matter may be adjourned for the day as Mr. KL is out of session. Your Lordship, we are yet to file the objection in this matter. We haven't received it from the department as of yet.
You have not received it. So we will not record anything regarding your objections, whether we are allowing you to file or not. We'll just have it fixed on another date. Yes.
No, I've been in jail for 4 years, 3 months and 10 days, my lord.
Hmm?
4 years, 3 months and 10 days. NDPS commercial quantity, my lord.
And the what
Trial
is the
is going on,
stage?
and out of 10 witnesses, 4 witnesses have been examined. Five, no? Five witnesses have been examined.
Hmm.
And 5 more witnesses are there, my lord, yet to be examined. Similar matter, your lordship has been pleased to fix a similar matter where our grounds are similar on 9th, my lord. Lordship may remember, day before yesterday, your lordship had fixed it on 9th. So may I pray this?
What is your ground? One of the ground is?
2 grounds here, my lord. One of the grounds is prolonged incarceration, my lord. So denial of Article 21. And the other is, my lord, non-compliance of 50 and 50A of this year.
On the 9th, a similar
9th,
matter, the learned counsel for the petitioner has submitted that no, the Miss So-and-so learned counsel appearing for the NCB has prayed for a short adjournment as the standing counsel, Mr. SCKL, is not able to appear in this court today. Full stop. Accordingly, list this matter on the 9th of January 2026, on which day the petitioner submits and the counsel for the petitioner submits that another matter with the same grounds are fixed. Yes.
Case diary was called for.
That's it submitted, looks.
Charge sheet be called for.
Eh?
And copy of the charge sheet.
Commercial quantity very recently it was student charge sheet, looks.
Very recent. Nothing will come. Why don't you take a chance there?
Lordship, as a lordship, say if you.
I cannot please myself to say that you should withdraw it. I cannot direct you to withdraw it. I cannot advise you to withdraw it. It is your decision. We'll have it at 2. Have instruction from your client whether you would like this to be closed and approach the trial court because the charge sheet has been submitted, or whether you would like us to call for the charge sheet. Then the matter will go to February because we don't have dates earlier than that.
Lordship, I'll appear before the trial court.
The learned APP has submitted that the charge sheet in this matter has been submitted before the trial court, being charge sheet number
2/25, dated 23/11/25.
So, on such submission, the learned counsel for the petitioner has sought for permission to withdraw this present application in the present form, with the liberty to approach the learned trial court with an appropriate application. Full stop. Permission granted. The bail application is allowed to be withdrawn with the liberty to approach the learned trial court with appropriate application for bail, which shall be considered on its own merits.
Please, your lordship.
Yes.
So NDPS intermediate quantity, 207.33 grams of suspected heroin was seized from a vehicle where I was also a passenger in that vehicle. Now I'm in custody for 48 days. Now there's one more thing. Well, here the police has also invoked section 27 capital A that deals with financing, my lord, financing of the drug trade. So if 27A comes, then the rigors of section 37 would also come, my lord. So one of the case diary is available here. Lordship may kindly examine whether there are.
What all were seized?
Seized, my lord, 207.33 grams of suspected heroin.
And
that's.
and
along with that, my lord, one mobile phone, two mobile phone. The
where is the seizure list?
Seized, my lord, I have annexed the FIR, my lord. The seizure list certified copy was not furnished, my lord.
Not
So
necessary.
FIR, your lordship will find at page 15 the list of the items which were seized, my lord. Number 1 is the contraband.
This forwarding does not contain the seizure list, sir.
No, it is there in the forwarding also, my lord, page 18. It's written there, my lord.
Where?
The follow, your lordship, this will be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 17th line, my lord. The following items were recovered by me during the search from the possession of them. Total 17 number of soap boxes, containing this much amount. Total 207.33 grams without soap box. Number 2, one Vivo mobile handset. Number 3, one ACE keypad mobile. Number 4, one four-wheeler vehicle. Number 5, one Oppo mobile handset.
No money. Yesterday's case, we found 27 rupees recovered. Then nothing. You are for Baharuddin.
Baharuddin, ma'am.
Investigation is at a very different stage, Lordship. Only
48.
Arrested when?
Arrested on 1/11/2025, my lord. So 48 days.
it has to be a trafficking part is also there, and he is financing the operation, Lordship.
Yes.
At this stage, let the investigation go on. When will come, and 180 days is the date, Lordship, of investigation.
When did you receive this?
That is.
When is the last entry?
Last entry.
31 10 29/11. Then 50. Oh. He has only started.
Very early stage, Lordship.
Hmm?
Very early stage.
Very nascent.
There's one more point, my lord. Your lordship will kindly come to page 16, my lord.
So that part we are not convinced. Now, page 16.
Page 16, my lord.
Yes.
There's a notice, my lord, under section 47. Relevant page 17, your lordship will see my signature, my lord. And I have specifically put it in my petition, my lord. This petitioner is not conversant with the English language. Your lordship can see his signature. Is unable to put his full name also, my lord. And I put it on in the petition that he is conversant only with the Assamese and Bengali language. And this was told to the IO that I do not understand the
Then
English
he
language.
must not have watched any Hindi movie till today.
My lord, on English, my lord, not Hindi, my lord.
So Assamese, English and Hindi.
No, my lord, understanding, my lord. To be able to read, my lord. He can read the Assamese and the Bengali language, my lord.
Yes, sir. Have your instructions on that? In a language that he understands is, I think, Mihir Rajesh. Huh?
Mihir Rajesh, my lord.
In fact, in affidavits, they are required to put that sentence for illiterate people that
It has been
the deponent has been explained what is there and
read on to.
In a language, has to be explained that we have explained it to them in a language which he understands or comprehends, my lord.
where is the remand magistrate order?
My lord, page 20, my lord.
Second paragraph.
Paragraph, my lord, Baharuddin portion, my lord, will lordship will find.
No, I'm just on page 20, the third paragraph
Third
from
paragraph,
the
my
top.
lord.
Okay. So let him have his instructions. We have produced the case diary as available today has been produced and produced. The learned counsel for the petitioner has submitted that it does not contain, that the allegation that the petitioner also alleges that he was not supplied the ground of arrest in a language that he understood. Understood, full stop. List again on 20, no.
And then, sir, it will be very long, my lord.
27th, not before that. 27th?
My lord, if it's not possible, then 27.
Because you see, we have the vacations.
My lord, I understand, my lord.
Then one more vacation in between.
My
We
lord.
are fixing up 20-30 cases a day. 27th of January, 27 of January 2026. By which time the learned APP may obtain the updated CD and also have his instructions regarding the contention on the language in which the on as to whether the petitioner was conveyed the grounds of arrest in a language which he understood. Otherwise, the CJM order says understood.
Their document does not, my lord. So anyway, my lord.
We will not disbelieve the CJM. Is it not? Have you received the case diary or something? What is your story?
Yes, Lordship. Page 11 is the FIR, Lordship.
We have read it.
Yes, Lordship. Lordship, the victim is minor, Lordship. She is a 16 years old, Lordship, class in 10 student. In the name of marriage, Lordship, the father had been extracting money from the petitioner, Lordship.
Okay.
Lordship, on last, the victim committed suicide on 2nd September, Lordship,
Yes.
3rd September, Lordship. On 2nd September also, victim received rupees 7,000 from the petitioner, Lordship. And the petitioner is daily laborer, Lordship. He works in Bangalore, Lordship. And on 3rd September, he could not receive her mobile call, Lordship.
Sorry?
The petitioner left her mobile in his room, Lordship, and he was engaged in his work, and he could not receive the call of the victim, Lordship. And as a result, out of emotion, the victim has committed suicide, Lordship. Immediately after the incident took place on 3rd September, next day, page 24, Lordship. Next day, the petitioner come back to his native village, Lordship. Also, visit the house of the victim, Lordship. This FIR was filed after 1 month because the petitioner asked for refunding the money. From
We will require the postmortem report, etc.
Yeah, but cause of death opinion still pending because
Cause of that would be pending, but the other opinions.
obligation and non-continuous.
No, not on that. Not on that. The sexual assault, if any, whether there was any history of that, perhaps we have to go through. And anyway, we have to allow the respondent number 2 to have her say. Or not, since he has appeared.
For 72 years, for 72 days, Lordship.
We'll have it as soon as possible. We'll have it on 21st of January. First available date. The only thing is that the victim is not in this world anymore. So even if we go by your story, the
Lordship,
payments made and all that. Who is this Papa?
Papa means father-in-law, Lordship.
Or to the
informant, Lordship.
This was sent to the informant by the
Petitioner.
By the petitioner.
Lordship, one thing is, Lordship.
Ah.
There is a suicide note, Lordship. Maybe in the.
Is it there?
Yes, right. But as per FIR, it is enclosed with the FIR, Lordship.
What does it say, according to you?
According to postmortem, according to suicide note, Lordship, out of emotion.
For not picking up the phone.
Yes.
Dangerous. Is it there?
That suicide is not part of it.
But then if you look at the FIR, where is that note? And the suicide note is enclosed with the instant FIR. Hmm? Learned Counsel appearing for the petitioner submitted that there was a suicide note left behind by the deceased victim, and the same has been stated to be annexed to the FIR.
Last line.
Huh?
Last line. Suicide.
We have seen that. Ms. So-and-so enters appearance for the respondent number 2 and prays for a short accommodation to have her instructions, complete instructions. The learned APP shall find out whether any suicide note had been attached to the FIR, and if the same is available, the same shall be also produced before this court. Not the same. And if the same is available, copy of the same will be placed before this court along with the case diary on the next date fixed. The learned counsel for the respondent number 2 shall also have her instructions regarding the suicide note allegedly left behind by the deceased victim. List the matter again on 21st of January.
Lordship, maybe 6th January, Lordship.
6th January, we have already fixed 22 cases.
5th January, Lordship. Already,
5th January it is.
Petitioner is 22 years old boy, Lordship. Only 22 years. Lordship, maybe 5th, 6th or 7th. Or 72 days.
5th of January. Yes.
May it please your lordship, on the last occasion, lordship, CD was called for.
Ah.
That is CD received.
Yes. CD received.
CD received, lordship. Custody for 35 days.
35 days, okay.
And the investigation on this case fully rests upon the documents here. And one website, your lordship. All have been seized, your lordship. Website has been blocked, lordship. Further custody is not necessary as far as this case, the nature of this case is concerned.
This WhatsApp, you had initiated it.
Lordship.
Huh?
Different context. Lordship will kindly go to the FIR.
Page? Huh?
What has happened, Lordship? One website was opened whereby, Lordship, jobs were offered. And the eligible candidates were asked to deposit a fee of 250 rupees. And it was in the name of, Lordship, Tata Semiconductor.
Assembly and Test Private Limited, Jagiroad, Assam. Yes.
It was a website. What happened? Persons, victims, Lordship, they applied. Thereafter, Lordship, this FIR was lodged by the, what do you call it, Lordship? The in charge of the Tata Semiconductor industry. No such job interview or jobs were offered by us. So apparently this is a fake. Police investigated, Lordship. Now, Lordship, kindly come to the forwarding at page 15, the relevant portion. Lordship will find point number 3. Four, 5, and 6. That person.
You received all the money.
Yes.
What is the total quantity received?
That is under investigation right now, and Lordship, he was arrested. Very initial stage of investigation, Lordship. His mobile phone, Lordship, he has been interrogated 4 or 5 times till date. And on each date, specific question was asked, where is your mobile phone? Because that is very relevant, Lordship. He stated that it was lost on 19/10/25. Thereafter, Lordship, the CDR analysis report was sought. It was active even after 1910. So he is lying on that aspect. And Lordship, repeated questions have been put to him that who are the other accused person? He has not named anybody. He is not cooperating at all, Lordship, in spite of being interrogated 4 or 5 times. Lordship, this needs the bank account statements have been collected for a time frame, Lordship. There it is seen that there are a number of transactions by victims who have deposited 250 rupees to him. But the other co-accused, they are yet to be recovered, yet to be arrested. So at this stage, it's not a fit case.
Lordship, the FIR was filed on 23rd October, Your
Hmm.
Lordship. But he got arrested in the month of November,
Hmm.
15 November. Your Lordship.
Hmm.
He was there in police custody for 4 days, Lordship.
Hmm.
He has given his statement, Your Lordship. The truth is that, Lordship, he's a rickshaw puller. Lordship, the statement. Originally, he's a rickshaw puller, Your Lordship. So that is the fact, Your Lordship.
Someone used his account.
Lordship, that may be, Your Lordship. That is
So that someone must have asked him money, which is deposited in the account.
no, Lordship, but
Unless you divulge some details, difficult.
Lordship, the nature of the case is on the basis of based on documents, Your Lordship, and this
Which
website-
document?
Those documents, Your
It is there in your
everything.
bank. The money is there in your bank. What more? What more do we need to see whether
And
you
the
are
account was deactivated within two to 3 hours, Your Lordship,
by?
by the police, Your Lordship.
Yes, that is what we are saying.
So as of my, as
It
to
is
my
not
knowledge,
only
no amount has been
it
deposited.
is
Your
not only about the evidence that they may collect. We also have to see whether there is a probability that you have done it or not, to some extent,
Involvement of other quick.
and the involvement of other two.
Lordship,
He's
it's been
zipping
2
up
months,
his
Your
mouth.
Lordship.
What
It's
can
been
we do?
2 months, Lordship.
Huh?
FIR was filed on 23rd October. Your Lordship.
Therefore, when the FIR was filed, no one knew. Then the account had to be traced. After the account was traced, the details had to be taken from the bank. That requires a certain procedure to be followed. Your bank details will not be divulged to anyone. So a detailed procedure has to come. Procedure came, man identified, arrested. The delay is nothing. That delay part we are not convinced. Convince us of something else.
Then also, my lord, it's
We are
been
eager. Huh?
35 days, my lord. Then also, my
Have
lord,
you cooperated?
yes, Lordship. I cooperated, Your Lordship. I've
And
given
you have not told them where the phone is.
my documents, my
How
laptops and
could you?
everything, Your
You are
Lordship.
inside. You are a rickshaw puller and you have a laptop.
That was given, that was in my house.
That was given to you. You are not divulging the names.
No,
Sorry.
Lordship,
Sorry, no bona fide, no bail.
Lordship, one more ground, Lordship. I have a 3-year girl, Your Lordship.
Understood. You have also a wife?
I have also a wife. Lordship.
Give us the bona fide. We are ready. You want to bring on record your bona fide? We'll keep it for some other date. You don't want to divulge your bona fide? After a month or two, with a new number 2026. Your choice.
It's maybe rejected, Lordship, because investigation has to go on, Lordship.
Tell us.
I have nothing to submit more, Your Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner also heard the learned APP. The case diary has been produced as called for, full stop. The allegation against the petitioner is that the petitioner's account had received the alleged application form fee pursuant to a fake advertisement issued. The learned APP has pointed out from the case diary that the petitioner has not been cooperating with the investigation. And despite 4 rounds of interrogation, he has not divulged the location of his mobile and other details of any co-conspirator with him. Full stop. The learned APP submits that the investigation is at a later stage and due to the non-cooperation of the petitioner, there is very little progress in the investigation. Full stop. The learned petitioner has submitted that the petitioner has a 3-year-old daughter and he is a very poor man and has been behind the bars for the last 35 years. We have considered the submissions made by the learned counsel for the parties. We have also perused the contents of the case diaries. Full stop. At this stage, this court is not convinced that the petitioner is entitled to the grant of privilege of grant of bail. Full stop. Accordingly, the bail petition is rejected at this stage of the investigation.
It's not dated 16/12/25.
Service not.
There is
Service not complete.
Complete, Lordship.
Service.
Is not dated 16/12. Actually, my POCSO is not applicable against this petitioner, my lord. But notice has to go, my lord.
What is the allegation against you?
Against me, my lord, that is at page, my lord, 44.
Huh?
Against me, my lord, the allegation is in page 44. Page 44, my lord. The serial number 4, Atabur Rahman. Against him, there is no POXO allegation, my lord. Allegation is that he has dismantled one motorcycle which was used by his brother-in-law, my lord, for the alleged offense.
The trial court records, a scanned copy of the trial court records have been received. The office note reflects that, does not reflect, no, the office note reflects that the service report on the informant is yet awaited, full stop. List again on 22nd of
Can it be in fast
January.
week, my lord, because here POXO, my lord, not applicable against him.
20 cases, each date
Yes,
has been
that I
fixed.
understand. How about they have written that?
You can take 21st or 22nd. One slot each is left.
21st.
21st,
Days.
yes, 21st.
Oblige, my lord.
28. He did not receive looks. Here, late resolution. Here, it was, my lord, a statement of a co-accused, my lord, no recovery from them, my lord. And on motion day, but we insisted that lordship there was criminal antecedents, my lord. That's why lordship was not that inclined. Well, here, my lord, already 43 days in custody, my lord. And if your lordship kindly have a look at the FIR, my lord, that we have annexed, my lord, page 15, my lord. Recovery is made from 2 persons, my lord. My lord, Sirajul and Shofiur Rahman, my lord. That is apparent from page 15, lord should find, my lord. Those 2 persons were apprehended, my lord. They were loitering, my lord. So there was some suspicion and there was some source information, my lord. So they were apprehended. In the FIR, it doesn't say that they took it from somebody else. That part is not there, my lord. But, my lord, lordship may kindly have a look at the forwarding report by which these 2 accused persons were forwarded, my lord. Page 23, my lord. It starts from page 23, but if your lordship kindly have a look at page 24, second para, my lord. That during interrogation, my lord. During interrogation, the previously arrested accused person stated that so and so. Definitely, my lord, during investigation, they can be arrested on the basis of statement of co-accused. That
So
is,
what has happened in the other case?
they are on bail, my lord. And it is 20 B, my lord.
Almost amounts to misuse of the bail.
That is
Where are
true.
the names cropping up?
But can I, my lord?
Perhaps in that bail also it was noted that they will not indulge in any other criminal
Definitely,
activity.
but here, my lord, only thing, my lord, that lordship knows everything, but 37 bar is not there, my lord. And for granting bail in a commercial quantity, my lord, case, my lord, definitely, my lord,
No,
that antecedent is very much, my lord, is looked into, my lord.
We are back to square one. If he had been inside, and at that point of time someone had named him,
My lord.
we would have definitely considered that he was inside. He's still inside and he's suffering.
One thing, my lord,
But,
lordship discretion, my lord, absolute discretion, my lord. And only thing, my lordship, if lordship is inclined, then any violation and any other case, it will lead
That
to
was already
cancellation.
given.
But that was
In
possibly
the earlier
not
case,
given,
it
my
was
lord.
given. He's not listening.
Possibly not given by because 37 kindly see once. I'm not going into that. My 37, that second part, my lord. That 37 bar second part.
That 37 we'll
And first-
look into that.
Yeah, and my
Let him at least have his CD before we
my lord,
consider
the
it.
mandatory period would be over in the meantime. That's why otherwise I would not have never prayed, my lord. And one aspect, my lord.
When were you arrested?
On 6th, my lord.
6/11.
So on
11.
4th, it will be over. And one line, if your lordship can.
Will be over.
And 20, and possibly my lord, the son, we have not stated that, my lord, off the record. Son is, my lord, he's also into, my lord, that. Can you have a look at that page 27, the rejection order once, my lord?
Son?
Simply that they all have it, my lord, that it is tablet, my lord, not huge quantity tablet, 5 strips, my lord. Kindly page 27, the rejection order, my lord. That last line, although it is regarding Sofiur, my lord, there is admission that he habitually consumed alcohol. Thereafter, it states that we have provided him. But, my lord, our instead possibly the son, my lord, both father and son cannot do this thing together. Absolutely, we cannot do, my lord. The son possibly, my lord, some, my lord, he is also substance abuse.
Just apart from the case,
Yes, my lord.
in most of the visuals that we seen in the movies,
Yes, yes.
the father transfers the business to the son.
Cartel.
The father and son can be involved.
Sometimes definitely, my lord. Yeah, lordship respect.
Anyway, it's a very what to do.
I have no legs to stand as regards the period of detention is concerned. It's
Ah.
already 42 days and it will be over.
Over.
But I can always pray for strict conditions.
Ah,
My lord, yes, yes.
strict conditions, and we will put it stricter than what was there in the last occasion.
Definitely, my lord, definitely.
Okay. Heard Mr. Swenson and Council paying for the petition. I also heard the learned APP. The case diary as called for is still awaited. It's still awaited. The records reveal that it was what quantity?
Lordship, net quantity will be 69.6 grams of tramadol.
Tramadol
Total 87.
was recovered from
Total.
two co-accused. Full stop. And on the two co-accused and on their statement, not full stop, not so and so amount was recovered from two co-accused, and on their statement, the present petitioners had been taken into custody. Full stop. We have seen the forward. We have seen the records annexed to the bail petition. We have also seen that you are Sofiul.
No, my lord.
Took them.
Motive and Bobby Dulmar. That lordship find page.
Your father and son.
My lord.
The
Is the forwarding report, my lord.
We've also seen the orders passed by the learned court in GR case number 569 of 2025. Full stop. In the facts and circumstances of this case, keeping in view the amount recovered, you have made that statement somewhere in the petition that you are already on bail on some other
That
case.
possibly not there, but
But-
that may be reflected. My what?
And in view of the fact that the petitioner is stated to be on bail in connection with some other investigation also, this court grants the privilege of bail to the petitioner. Stop. Accordingly, the petitioner shall be released on bail on providing a bond of rupees. What was the last amount? We don't know. Bond of rupees 50,000. With two sureties of the like amount, subject to the satisfaction of the
This additional district session judge, my lord, Bilasapura, Dhubri, that is page
Bilasipura
23.
Dhubri, and also subject to the following conditions. One of the conditions would be, in case the petitioner is found to be accused in any other case, henceforth, the privilege of this, state would be at liberty to inform the same to the court for cancellation of this bail.
Of similar nature, my lord, possibly.
Of similar nature.
Yes, possible.
Have to peruse paragraph number 12 for a minute.
He will then go for some other nature crime.
Pointing at outlook.
Yes, please.
12 of the petition.
That instruction was possibly not there, my lord.
This changes the color of everything.
Not have happened. Set to set.
Mr. Chaudhary, para 12 is very.
Something, yes, sir. But we here, always denials are there, my lord. It doesn't say that as well as in the instant case.
And if it was a total oversight, we would have considered. Apparently,
Forwarding report is clear, my lord, that there
they
other
are
cases
engaged.
there, my lord.
No, in light of certified copies being here and that statement wrong in the petition,
Statement in a sense, my
should
lord,
we?
here we did not say that there is no other case. Well,
No,
it
you
says
said that he has not engaged in any sort of activity as alleged in the instant case, the same activity. It has to be the same activity.
That is true, my lord, but here with all respect, my lord, kindly strict condition as lordship has already
I
granted.
understand that, but
Given.
difficulty is this part, no? Council's filing it without
But that is true, my lord. Lordship may excuse this as a first instance, but kindly.
your petition.
My mistake, my lord.
It is not your mistake, Mr.
My
Chaudhary. We know well, and we know well enough. This kind of protection is leading people to file.
Yes, sir.
Our belief is being broken.
My mistake, my oversight, my lord, definitely.
Out there, we only see black and white. We trust the black and white.
Yes, yes.
To every extent.
Forwarding report is clear, my lord. So there is, nobody can, my lord. My lord.
That is
conceal
the
that.
affidavit is by someone else.
Just pointing it out.
It needs to be.
Normal DDA.
We will see what is to be done with that paragraph. Now, this has made us more cautious in every case.
Yes, sir. Your
What do you say?
Exactly.
Once bitten, twice shy. Yes. How come that statement has come? Huh?
I'm sorry, my mistake. May I take it?
When you take it upon itself, it is becoming difficult. Yes.
Much obliged.
Disposed of.
Highly obliged.
29 of its CD has not been received.
Lord, this is regular bail application, my lord. I am behind the bar since 32 days, my lord.
Mm.
My lord, everything recovered, my lord. This is a case of theft, my lord. FIR is at page number 10.
What did-
Relevant portion is at
What
page
was stolen?
My lord, one vehicle and some articles, my lord. May I read the FIR, my lord?
I think we should await the CD.
My lord, everything recovered, so was the forwarding report, my lord. I am not the driver.
No,
The whole allegation is against the driver, my lord.
You are who?
I am a laborer, my lord, of tower construction company. One Manush Pratim Duara is the, my lord, driver. Only for a moment, may I read the FIR, my lord? Page number 14.
We've read it.
Today morning, our driver Manush Pratim Duara, who is engaged as a driver of our rental Bolero camper bearing registration number has informed me over telephone that the Bolero camper AS01 has been missing from our store yard, and he also informed that the vehicle has been parked at Dhaligaon police station. I immediately rushed to the Dhaligaon police station and come to know from the officials of Dhaligaon police station that the said vehicle has been caught by the Dhaligaon police station patrolling police officers at Tapaguri area.
It is awaited, sir. Huh?
Received.
CD is not received.
32 days, my lord, 60 days offense, my lord. So, my lord, at any stringent condition, my lord. At any
Stringent condition is not working when the person allegedly confesses.
No, my lord, then everything, if I confessed, but then everything, my lord, happened, my lord. So nothing, no new fact will come, my lord. Assume I have confessed, my lord, then everything, my lord. But the custodial detention may not serve any purpose, my lord. At any condition, my lord. Never are, my lord.
What about the driver?
My lord, I have no any instruction about the driver, my lord.
Any indication where was the vehicle recovered from?
Dhaligaon police station.
No, it is with the Dhaligaon police station,
Right.
but where has it been recovered from? We will have to wait, sir. There is another police case regarding theft from the storeyard.
Perhaps not against me, my lord.
Perhaps that is why we had kept it. We'll wait the CD. 8 fully.
Long vacation, my lord.
8th of January. Can you have it up by the 8th,
Yes, yes.
Mr. Sharma? The learned APP has submitted that the CD is awaited, list again on the 8th of January, by which time the receipt of the CD shall be ascertained.
9 supplementary.
We were on that, huh?
My lord, it has to bring some instructions.
They are perhaps busy in some investigation. Huh? They are not in investigation. This is item 49 supplementary. Key hai sir? 49 supplementary bail hearing. We'll take it up a little later. One or two, 3 matters to go.
3 matters to go, my lord.
2-3 matters to go, if I'm not wrong. Keta ase? 50 ase, 51 ase. Ifale order ekita. Sari. Ifale nai. Order side hai ase? 36 or 39 side. Ifale eta 5ta. Bail hearing eta 6ta. 6 matters. 6 matters. Let us complete that part.
In the meantime, I'll inform them also.
Helpful.
If the lordship will kindly peruse the office note dated 17/12/25.
But we have taken steps long back, but the registry has sent it on 16th, Lord. If Lordship sees. This has been issued to Karimganj police
16th.
station. Lord, if your Lordship sees the notice, there are 2 information that has been sought. One from the special judge court, where Lord, in the mail, there is an annexure of our bail petition. But the notice which has been sent to Karimganj police station, only the order of this honorable court and the notice has been sent. If it has to be served, my lord, because it is mandatory that they should receive the notice. And Lord, again, they will take time, Lord. But he is under custody, Lord. It's a matter of love affair between the parties. And that Laila Majnu case.
This is, we find it very interesting in the POCSO matters. It is after something grave happens that love emerges.
Oh, yeah. Emergency is earlier than grave. The case is other way around.
Anyway, the heard Mr. Swensol and counsel appearing for the petitioner also heard the learned APP, the office note dated 11/12/2025.
I have one prayer, if your lordship.
17/12.
Yes, no. 11/12/2025 records that steps had been received and notices issued to the respondent number 2 through a memo dated 11/12/2025. Full stop. However, the same receipt by the public prosecutor is seen on 16/12/2025 and the office note dated 17/12/2025 reflects that service report on respondent number 2 is awaited. Yes, what is the prayer?
But they have sent it under the notification, but it has to be served through the concerned PS. They have sent through mail only the order copy and the notice.
Okay.
But my prayer is, since they have a copy, scanned copy of the petition, which has been served to the special court. This also should be served along with the notice, Then only the service would complete. So they have a right to object to my bail petition. They will only object once they come to know what my.
It is available in the TCR. No, it is available here in the court.
When they, yes.
It is available with us in the court.
Yes. In the notice, the mail which has been sent to the special court, there they have annexed the bail application. In the email, attachment is there. But that attachment has not been sent to Karimganj police station because that would expedite. Otherwise, only copy of the order will not be an effective service. After flag A, there is order copy and there is the mail. I've checked up from the record.
Email so and so.
The mail sent to the special court. My lord.
Ah.
There your lordship sees attachment. Mail application is there, your lordship would see. There the entire record has been, bail petition has been sent to the special court from where the TCR has come in scanned copy. But so far as Karimganj police station is concerned, it's only the notice has been.
The registry shall, it goes through your office or the
Yes.
registry? Through your office, through your office. The learned APP is requested to forward a copy of the scan copy of the bail petition file to the concerned police station so that the same may be served upon the respondent number 2, since it has been stated by the learned counsel for the petitioner that perhaps through inadvertence the scanned copy of the bail petition was not forwarded with the notice. List again on.
Can I pray for 7th? Or 9th, my lord?
The 20-25 cases already fixed.
We understand, my lord, but in this kind of case, he's been not. Take a chance on 9th, my lord.
9th of January.
If you're wrong.
What do you want?
Here,
Yes.
amicus may be appointed, lordship.
Amicus list এখন আছে।
মানে লৈ লওঁ।
হ্যাঁ? Amicus list কোন দিয়কচোন। এইটো অহাতে ল'লো। The service on the respondent number 2 is complete. None appears for the respondent number 2. Service on the respondent number is complete as per instructions received by the learned APP. This court appoints D.K. Bhattacharya as the amicus to assist the court. Instruct. Learned counsel for the petitioner shall serve a copy of the bail petition on the learned of the petition on the learned amicus. List again on AB. 8th of January, AB.
Can you give 7th if possible?
Will exceed the 7th.
7th. Much obliged. Much obliged.
Yes.
Lordship, 482 application, Lordship. FIR is at page 8, Lordship. Allegation is that I have been making obscene gesture through messages and threatening of her telephone. This is the only allegation, Lordship. Lordship,
To whom? You have been making it to whom?
to the victim, Lordship.
And who is the victim, lordship? That is a pertinent question.
Huh? Where is the FIR?
Page 8, Lordship.
Lordship. Scan copy, everything will be good.
Huh?
Only take up the scan copy, lordship. I have flag mark, lordship, the statement of the victim. So the statement of other witnesses, lordship. Already charge sheeted, lordship.
When arrested?
Arrested, Lordship, anticipated.
Anticipated.
And cognizance has been taken already, 2011-25.
Just seated.
Cognizance has already been taken.
Will protect you for a certain time, go and appear before the trial court, pray for regular bail. Please charge sheeted.
Lordship, two sections
And-
are bailable, Lordship. Only one section is non-bailable.
Do you need more non-bailable sections
No,
inserted?
No, Lordship.
Then
Lordship, in fact, I
one
am a
is
married
enough.
person, Lordship.
Huh?
Lordship, I am a married person, Lordship.
Ah.
And I have two sons, Lordship.
Ah.
And in fact, Lordship, victim is my wife's nice, Lordship.
That is the difficulty. That exactly is the difficulty. That is the difficulty. We'll protect you till January. We'll protect you till 9th of January.
Okay.
Appear before the trial court. Pray for regular bail. They'll consider on the materials available. And had Mr. So-and-so learned counsel appearing for the petitioner, also had so-and-so learned counsel appearing, learned APP, full stop. The allegations against the petitioner is that he had been indulged in giving derogatory and threatening messages to the niece of his wife, full stop. The petitioner remained absent during the petitioner could not be apprehended during the investigation period, and the charge sheet has been filed. Full stop. The learned counsel for the petitioner submitted that that the petitioner would be ready to participate in the trial proceedings. Given the opportunity, however, he apprehends that on his appearance, he would be immediately put behind bar since he did not get the opportunity to participate in the investigation process and may have been shown as an absconder, full stop. In the given facts and circumstances, this court directs that the petitioner shall not be taken into custody till the date of his appearance before the learned trial court on or before 9th of January 2026. Full stop. Upon his appearance before the learned trial court, he shall file an petition praying for regular bail, which will be considered by the trial court on its own merits. Full stop. May be disposed of. He will not be arrested till his appearance on or before 9/6. Will not be arrested. Go and appear. Here's the music. Take this down. Add one more sentence. The petitioner is also the petitioner is also directed that in the meantime, he shall not in any way communicate with the alleged victim or the witnesses in any manner whatsoever. CD not.
Also matter CD not visible. Steps have been taken.
And APP has submitted the CD has not been.
There is also office not, Lordship, I have not.
15/12. Like why? It has been sent only on 15/12. It has been sent on 15/12.
That part was not clear whether it should be registered post or through that part was not clear in the last order. There was a difficulty on there. It was written as registered post.
Registered post.
Because it should go through the registry. That is the.
By the last order date 27/11/2025, the notices were required to be issued upon the respondent number 2. 2 steps taken by registered AD, full stop. The learned counsel for the petitioner is given the liberty to take appropriate steps in consonance with the prevalent notification for service of notice on the respondent number 2. List again on
22nd January.
it goes a bit late.
22nd January.
22nd of January 2026, along with service report.
Clearly.
Learned APP shall also procure the updated CD.
34 Lordship, charge sheet submitted.
Charge sheet has been submitted, sir.
My lord, LCR, my lord, maybe call for my lord, because
TCR may be called for. The learned APP has submitted that the charge sheet has been submitted in the aforesaid in the present case by charge sheet number
White charge sheet number 160/25 dated 3/11/25.
Stop.
My
Charge sheet has been submitted. It's an AB.
Yes. They have not cooperated in the investigation.
my lord, I also filed.
We will protect you till 9th. We will protect you till 9th. Go and appear before the trial court. Move a petition for bail. They will consider. Stop. The learned counsel for the petitioner submitted that the petitioner is willing to participate in the trial proceedings, although he could not participate in the although he could not participate in the investigation part. Full stop. Keeping in view the submissions made, it is provided that the petitioner shall not be arrested. Huh?
With respect, Lordship, will it amount to
No, we are allowing him to appear there.
any sort of protection may be?
No, my lord, we will appear there. my lord.
Then we'll have to dismiss this. The charge sheet has been submitted.
The best way is to let him to approach the concerned court, Lordship, because he has already not approached the concerned court first before applying for AB in the High Court. A specific direction in one of the cases of the
Okay.
High
My lord,
Any relief granted, Lordship, will be
No, my
against
lord.
the notification.
my lord, then my lord, if my lord,
No, I cannot grant it beyond the notification. We cannot grant it beyond the notification. On the earlier case, it was not a POXO matter. This is a
then my
POXO.
lord, CD may be
That
called
was
for.
not POXO.
Huh?
Yeah,
Huh?
copy of the
That was not POXO, so we did not take that into account, but this is POXO, we cannot.
Then my lord, scan copy of the. CD.
What did we say? Has submitted that the case has been charge sheeted by charge sheet number so and so, so and so, so and so again, full stop. The learned counsel for the petitioner has prayed for calling of the scanned copy of the trial court record, full stop. On his prayer, call for the scanned copy of the trial court record, lists this matter again on the 28th of January 2026.
Apply. Supplementary 51.
Lordship, Mr. Esnawaz is on his legs in court 6.
Sorry, my lord, I was doing an amicus matter.
No issues.
Well, this is that matter which came up day before yesterday. Petitioner.
Oh, yes, he's
his exam was
scheduled
there.
to appear in the examinations. Yes, Mr. Pukon.
Not 17, my lord, the age of the
18.
victim is 17 years, man.
The FIR is it, please.
That is fine.
It's 10, my lord.
Pages are a bit.
Huh?
Statements will start from here, then possible to come here, Lordship.
Yes.
My lord.
What is the story given to you?
The story, my lord, as per the FIR. FIR itself says that there was a romantic relationship
Mm.
between the, of course, my lord, the age being, the girl being a minor,
Mm.
that does not itself exculpate him, my lord. But as per the FIR, the informant, who's the brother, says that they have been in a relationship for 8 to 9 months. my lord.
Mm.
Subsequently, they went to Tamulpur together, where they stayed in a hotel near Rongia station.
Exactly the same thing. Now, why step back after all this? We cannot act as a conciliatory body, but why step back after all this?
Well, he is 22. He is studying in fifth semester, my lord, BA fifth semester. She is also a minor at this stage, my lord.
That studying part today, we have, I think, allowed someone to be taken to the examination center. That will be taken care of.
If he is
We'll
in
provide the
custody-
books.
If he's in custody, my lord, that can be taken care of. But since he has not been arrested, if at this stage, my
We
lord, he
don't
gets-
think that with the type of statements which have come, should be allowed to roam around.
that is, of course, subject to your lordship's discussion. Your lordship may allow or reject.
No, you have to convince us.
My lord,
We
my-
just
my
speak our
con-
minds. We
my
do
lord,
not.
my contention before your lordship is
Just a minute. We never try to impose the order. We have been speaking our mind not only to you, but also to the PP that this is where we think he should be allowed to go. He has objected. We have changed our minds. There have been times when we say that we don't allow you to go. We have been convinced enough to allow the petition. Convince us.
My lord, my submission before this honorable court is that your lordship, because I do not know the exact contention in the statement, my lord, but if we go by the FIR, his age is 22, her age is 17. No matter, law has drawn a line at 18. That nobody can change it, my lord.
Okay.
But the fact is the ground reality, my lord. Adolescent relationships are happening, whether the state draws this line or not. These relationships are happening, and nobody can stop anybody from having this relationship. Of course, if they cross that limit and they engage in some sort of a sexual relations, POCSO will come. But my lord, at this stage, that issue can be examined by the trial court also, my lord. At this stage, we are only on the point, my lord, whether his custodial detention will be necessary for the purpose of the investigation or not.
His activities after the incident is the pain everywhere here.
I'm not.
He refuses to acknowledge. They allow the lady to stay at the home, and then he refuses. He says, "Go home. I'm not interested. Enough is enough."
What my respectful submission would be that his age, my lord, at this age, my lord, that can be taken as a mitigating factor for this, because at this stage they cannot marry also, my lord, because she is a minor. At this stage, if you go for marriage, that is also again something which is void in law, my lord, and that will also give rise to another prosecution. Unless and until that threshold is crossed, my lord, then perhaps a decision can be taken by the families of whether to go for a marriage or not. Since at this stage, marriage would otherwise not be legally permissible.
In October, she was 17 years.
17 years.
But it's
Yeah.
11/4/2008.
11/4/2008.
Time of occurrence, date of occurrence is what she.
In October, my lord.
Eight.
So she would be around 17 years and 6 months.
2020. Huh?
17 years and 6 months, my lord.
Prior to the lodging of the FIR for about 8 to 9 months.
So around 17 years, and she will attain majority, my lord, if going by that age next year in April, my lord. Then perhaps if the families can take a decision.
No, it is not. The families have refused. That is the problem.
Yes, my lord, I understand that, my lord.
The parent, no, the parents have asked. That is also one line of thinking. How can the boy's parents ask her to stay back? They'll become party to the entire fiasco. The logical part was to send back. That is not difficult. But logical part is to send back, and
She'll end up losing a year, my lord, if some protection is also not.
he's ending up losing most of her dignity. Is it not?
At this stage, my lord, irrespective of how one thinks, my lord, about adolescent relationships, that one presumes that they would be platonic, my lord. But ground reality is that they don't end up being platonic, my lord. In these facts, my lord, this is not.
Yes, sir. What do you say, Mr. APP?
Commission will be holding a 22-year-old boy adolescent should not be correct.
It is not adolescent. Adolescent, we are not convinced, but
He will be in a higher secondary and he will.
Endorse the view of the
He will be, he is in his college, my lord. She will be in her.
The dignity of the victim, my lord, this side losing a year, man. You can't come.
Yes,
That dignity and year, my lord, they cannot be compared. my lord.
that was a
But my-
sentence he picked up.
My lord, my submission, my lord, he is a college going student. She is in her 17, about to be 18, so she will be in her higher secondary, my lord. At this stage, my lord, whatever relationship they had, this is not like the not traditional POXO cases of my lord, abuse and exploitation, my lord. This is a case where they were in a relationship, my lord. Not a case of exploitation or abuse in the traditional sense of other POXO cases.
I've been, High Court should encourage first approach the courts below lordship in case of. Division bench of the Supreme Court. Section of the division bench of the Supreme Court.
So this matter has been referred to a three-judge bench, my lord. So the answer to the reference is awaited. And
No,
one
this
more
is-
aspect is here, my lord, this is a POXO case. So the sessions court will be the original, unlike a magistrate case where the session court sits on a superior level, my lord. Here the session court will be the original court of jurisdiction. So we have come before this honorable court. And another aspect, my lord. This case is of Kamrup, my lord, and the petitioner is of Nalbari, my lord. One of the points which the learned amicus in this matter had in his report submitted, that one of the cases where exceptions can be made for this rule is that where the petitioner does not reside in the area where the case is lodged, my lord. That was the report. Obviously, my lord, now
Then
reference is
the,
pending,
then
my
the,
lord.
then the question of influencing comes down.
My lord, because he is from Nalbari and she is from Rongia. My humble prayer, my lord, in these facts, my lord, this case may not be considered like the
So
traditional.
look at the family, they are allowing the lady to stay outside for the night, not inquiring about it, then coming to know about it after 4 months, 3 months, 2 months. It's an AB. It's another issue.
Well, had it been a case of normal abuse and exploitation, my lord, there would have been no case for the petitioner. Had it been a case of, my lord, a traditional case of POXO abuse, my lord, exploitation, perhaps, my lord, in that case, there would be no case for the petitioner. We are in these facts, my lord. Perhaps the facts can be taken as mitigating factors.
The medical has also been refused. So it will be statement versus statement all throughout. That part not being proved, it will be only test. Allow him to appear. Let him study. Girl does not Mr. Swenson and a counsel appearing for the petition also heard the learned APP and the learned amicus.
Respectful submission, lordship, merits of the case.
I will not. The case diary as called for has been received. We have considered the submissions made on both the sides, for both the parties. We have also produced the case diary. The petitioner, it has been submitted that the petitioner is a college going student and the relationship between the petitioner and the victim who is on the verge of attaining majority was consensual, and there is no till this point of time there is no direct evidence of any assault to the detriment of the victim. Full stop. We have also gone through the statement of the victim girl. Taking into consideration the entire of the matter, this court grants the benefit of rearrest bail to the petitioner on his submitting a bond of so and so. Make it 20,000, two sureties of the like amount. Subject to the following condition of the investigating authority. Subject to the satisfaction of the investigating authority, petitioner shall appear within a period of 10 days before the investigating authority. The petitioner is stated to be, as the petitioner is stated to be from Nalbari, and the victim girl is from another district. Huh? From Rongia.
Victim case is registered at Rongia, my lord. Victim's address is at Borazal. That is also under Nalbari.
Nalbari, huh?
Nalbari.
The accused shall not, the petitioner shall not in any manner contact with the victim during the entire period of investigation. Let him go to college.
I'm deeply obliged.
এইবিলাক ৰাখিব সেই not in any other offense অমুক তমুক সেইবিলাক না কণ্ডিশ্যন এখন কি হয় এইটো disposed of
If the service in respect of respondent number 2 is complete, so MIS can be appointed.
The IML that has been filed for
bail. What is the punishment given, sentence given?
7 years, Lordship.
7 years.
Fine of 10,000.
The court is also not satisfied, my lord. The incident, my lord, only one, my lord, the exhibit.
Without the amicus, perhaps passing of any orders would not be appropriate. Let us appoint the amicus. We'll have it on the 5th.
9th.
Cases where persons are already in custody, we are fixing at the end of January. Anticipated bills we are considering, but
The March, my lord, he is, my lord, inside, my lord. Absolutely no case, my lord, here, my lord.
15 days more than what we proposed.
Is it, please?
Another 15 days. We proposed 5.
Okay.
Add 15 to it.
On 30th in that case.
Huh?
30.
30 December, 30 January, yes. We can have it 30, we can have it on 27, 28, your convenience. Heard Mr. P.J. Sekar, learned senior counsel appearing for the, assisted by Mr. So-and-so appearing for the petitioner, also heard the learned APP. The service on the respondent number 2 is complete. However, now none appears. Therefore, this court appoints
28.
Srimati Manisha Karen Brown as the amicus curiae to assist in the matter. This is the matter again on 28th of January 2026. The learned counsel for the petitioner shall furnish a copy of the
By tomorrow.
appeal and the IA criminal to the learned amicus curiae in the meantime.
Obliged.
Amicus,
Your Lordship, the matter may kindly be taken for some time.
Sai number, huh?
So matter may be kindly taken up for some time.
Sometime. This is for what? Edu ki hoga nahi se? Item 30?
This were issued, Lordship, to the respondent number 2, last occasion. The case relates to quashing of the pig. FIR as well as the charge sheet. For quashing of the FIR and the charge sheet. APL, Lordship.
Service report is awaited. Who is appearing? We will wait, we'll just wait for some time. Yes, madam is madam. Service report is awaited.
Respondent number 2 yet not appeared, but in the meantime, Lordship, the trial proceeded, so I have filed one IA.
Yes.
Some period, Lordship, stay may be till her appearance, Lordship. IA criminal
Unless-
1358.
Unless we know what is the
Lordship, in this case, what happened? FIR was lost against the petitioner. Case 14, Lordship, Annexure 1. Against the petitioner on the allegation that he taken her to Hyderabad and stayed for 1 month and later, Lordship. May I read, Lordship? With due respect, I have the honor to state that on last 8/10/24 in the evening about 5 p.m., the below mentioned accused number 1 with a promise to marry me took me to Hyderabad from Jograpar. By staying there, he committed sexual intercourse with me against my will. Whenever
why should we interfere?
Lordship, she is aged about 33 years and the boy is aged about, Lordship, it's a complete false allegation. We
Why is aged about?
23 years, phase 2.
Ah.
There are
Let
some
me-
family relation, Lordship, to help her with, he took me along with her to Hyderabad for her husband's treatment, Lordship. So for some treatment.
She is married.
Yes, Lordship. She is a mother of 2 children, Lordship. Charge sheet was filed on some other allegations, sir, Lordship.
When is the next date fixed?
Next date I have in IA enclosed the copy of orders is 7 to 9 page, Lordship. Next date is 2/1/26. And some protection may be granted, Lordship.
No, we'll give you the liberty to inform the trial court about the pendency of this case. Pray for the matter not to be taken up on that day. And we'll have to await the service report. We will not pass an order of stay. Blanket stay will not give. You can inform the court, we'll give you the liberty. Inform the court that already it is there. And that the IA is under consideration.
Boy is
Mhm.
Boy is in Delhi. So there is a problem, Lordship. Filing of this, he went to Delhi for his
Ah.
livelihood, Lordship.
We're
His
not asking.
presence may be required while filing the petition before the London trial court. Harassing the petitioner by the lady, Lordship.
You have quite some time to have the affidavit sworn at Delhi also. It will come back if you can draft it and send it, it comes back. Inform the lower court now without the nature of the allegations. To believe you, we must have someone before us. Is it not? Yes.
Lordship, those sections were already, Lordship, cut off from the FIR. Some other sections were incorporated in the charge sheet, Lordship. Only 376 and all this, Lordship. So that is why I have filed this quashing petition, Lordship. Page 7 is the annexure A, Lordship.
It is only charge sheet. It is only a difference in the FIR and the charge sheet.
Yes, Lordship.
Charges have not been framed and they have not been deferred. It will be upon the court to look into the charges.
Charge
Is
sheet
it not?
was filed on some other sections.
No,
page
whichever section, it differs from the FIR. During investigation, they may have found anything, they might have changed whatever they want to. This has not become a court record till now. The court is not proceeding on that. It will be heard before the charges are framed. So, we'll allow you that liberty to inform the court that this petition has been filed. There is an IA for stay pending, and only due to heard Ms. R. Chaudhary, learned counsel appearing for the petitioner.
We are through an engaged counsel, Lordship.
To Ms. R. Chaudhary, learned counsel appearing for the petitioner, also heard the learned APP. This office note reflects that the service report on the respondent number 2 is awaited. Full stop. This IA has been filed praying for stay of the proceedings before the learned trial court. Full stop. In the facts and circumstances of the case, this court gives the liberty to the petitioner to inform the learned trial court regarding the pendency of the criminal petition and the present I, and inform this one so and pray for inform the court, full stop, regarding the pendency of this case, full stop. It has been submitted by Ms. By the learned counsel for the petitioner that the petitioner is presently not available in the is not presently available in Assam. Stop. And not full stop, comma, and despite his efforts, it may not be possible for him to return back. Stop. If such be the case, the petitioner may make alternative arrangements for preferring the appropriate application before the learned court for consideration. Place this matter again on, you have it on 28th of, no, we'll have it on 30th of January 2026, along with the service report on the respondent number 2.
By engaging an counsel, Lordship. Application may be filed through an.
We have said alternative arrangements.
Lordship, by any family member, he can.
We have said alternative arrangements. It is to your discretion.
Lordship,
Why
oblige.
should we bind you down?
There will be a common order in both the cases, Lordship, IA and criminal petition.
Yeah, everything will come up again.
Oblige.
Today we are only considering the IA. The others were not before us.
Oblige.
Yes.
May I please, Your Lordship?
Mm.
Lordship, as per office note dated 16/12, no AD card or unserved notice has been done in respect of respondent number 2. And there is no update in respect of respondent number 1.
Await service report on the respondents.
Respondent. Lordship.
Stop. Place this matter again on 30th of January.
Lordship. Lordship,
Interim
interim
orders passed earlier shall continue.
Highly obliged.
Please.
Yes, sir.
My lord, this application is filed for questioning the entire proceeding of special P case arising out of child marriage and POXO, my lord. My lord, at the time of marriage, she was, my lord, 17 years, 19 days. Petitioner is the husband of the, my lord, alleged victim. And now she is, my lord, around 20 years and one female child, my lord, they have gone out of their marriage. And they are happily, my lord, living together, my lord. Affair is pays, my lord.
Stage of the proceedings in the lower court. What is the stage?
That, my lord, charge sheet file, my lord. And similar case, my lord, your lordship, my lord, called the proceeding.
What did I do? I must have done something devastating. Huh? You are for the and you are agreeable. You are for the
Respondent
number 2 is who? Damada?
White, my lord, white. Now she
You
is
had lost
major.
it.
No, she is major, my lord.
No, who filed the FIR?
Person, my lord. Is not a family member, my lord.
What was this?
One VDP personnel, my lord, filed this FIR, my lord. Page, my lord, 11, page 17. FIR, my lord.
This is what we are doubting now. Even if she is a major, no conviction, can it be there? The trial proceeds. She has now become a major. Since the so-called victim girl has come forward to state that she has been living happily with her husband, there is no possibility of conviction. Therefore, we have quashed the proceedings.
The Date of occurrence is relevant at this stage.
So she was a minor. Conviction will be there.
My lord,
Why don't you take this up in appeal?
minor marriage, my lord, minor marriage is not a void marriage, my lord. It's a voidable marriage, my lord. At the time of my lord,
There are allegations of POXO here.
POXO, my lord, is not attracted, my lord,
Will not be attracted.
my lord. Because
When was the child born?
marriage, my lord.
When was the child born?
Child born, my lord, on
Date of birth of child.
at the time of she was found major, my lord. I have annexed the my lord birth certificate.
Huh.
Child born on my lord 5/11/2023, my lord. 5/11/2023.
5/11/2023. And when did she attain majority?
She attained majority on my lord. Marriage took place on my lord.
When did she attain majority?
According to her affidavit, Lordship, her date of birth is 1/1/2006,
Hmm.
1st of January 2006.
So she attained majority in 2024.
My lord.
So the child is born prior to her attaining the majority.
Majority.
POXO hence proved.
My lord, one Supreme Court judgment is there, my lord.
Yes, so as that. That will help us. Definitely that will help us.
A child born on at the age of 14, first child. Then second child on 17.
And Supreme Court said
Since they are happily, my lord, keeping their life, my lord.
the sentence was set aside.
The proceeding was crossed.
Is it?
Sentence and my lord, conviction was. My lord, page 3, my lord. Page 14 years.
After this, that judgment has come in the adolescence. Yes, what do you say?
Then there are several other
What do you
judgments
say?
from this honorable court. Other than I have annexed one judgment from the coordinate bench, my lord. The affidavit is page 35. my lord.
Huh?
Passing, Lordship, there is no impediment as such, Lordship.
Have you contacted the victim or is it just, are you in touch with the victim? Huh? Yeah, we are pushing it what to do. Disposed of. Allowed.
Highly obliged.
Petition allowed.
There is no chance of fiction.
Till the time we take up the other matters, you may perhaps go through this. We have taken that in the other case also. They have placed my judgment before me. The court is of the opinion that so-and-so is applicable. Since the so-called victim girl has come forward to state that she has been living happily with her husband and she is now a major. In such a circumstance, there is no possibility of conviction of anybody in the future.
By judgment will also come in.
Huh?
But by judgment, Lordship.
This one we are referred to Bhajanlal, following a coordinate bench.
But by also stated that offences in which there is that scope is there.
More so if it is a family matter, now
Yes,
it
yes,
becomes a
yes.
family matter.
Yes.
Supreme Court has also said that. But there it was the uncle who had arranged the marriage.
Yes.
It was not POXO as such.
Forward by Lordship, different scenarios are there.
Yes, next day disposed. Allowed.
Obliged.
Huh? বাকি দীঘল অর্ডারটা চেম্বার দিতে 17 time meeting. None appears for the petitioner on call. None appears for the petitioner on call. List again on 30 January 2024. 2026. হৈ গ'ল? এটা থাকি গ'ল। 49 to do. Hearing to over. 49. Is anybody here for item number 40? Item 40, you do it.
Here already, matter is amicably settled. Probably your lordship can close this matter.
We need to close it only.
Because that matrimonial dispute which lordship raised to that dispute between the husband and wife. Subsequently, husband filed a FIR alleging that his gym was closed by his father-in-law. So accordingly, FIR was registered and the gym was seized. And he filed subsequently a Jimma application. A Jimma application was allowed by the CGM lordship. Against that order, father-in-law filed a revision. So revisional court lordship did not interfere. Did not interfere with the matter. Only said that you execute a bond of rupees 5 lakh, bank bond of rupees 5 lakh. And after passing of that order was passed on 14th. On 16th, he died. So the petitioner could not execute that bank guarantee, lordship. And subsequently, lordship, that he executed that bond, but that was subsequent to that taking that Jimma, lordship. Now, mother-in-law comes into picture and she filed a revision, lordship, whereas she was not a party to the proceeding. She filed a revision saying that the Jimma was given prior to execution of that bank guarantee. So court directed that trial court that to look after the matter and file a complaint if necessary. Against that order, I am before your lordship. Now already everything settled, husband and wife living peacefully together, lordship. That's it.
So will we say that we have heard the contesting counsels for the contesting parties who have submitted? Likhi jo.
Yes.
So and so appears for the petitioner, so and so appears for the respondent.
Number 2.
Respondent number 2. State has no objection to us closing it. Okay. Also, Mr. D.P. Goswami learned APP, full stop. The counsels for the counsels for the contesting parties have submitted that the matter has been amicably settled and they do not want to further proceed with litigations in the current issue. They are
Leaving.
we are not going into all that. We will simply say that you do not want to engage yourself in litigation, in the present litigation any further. In that view of the matter, both the parties have prayed that the matter may be closed without further adjudicating the same. Full stop. The prayer is allowed.
Party part has to be set aside, lordship.
Which party part?
That page 46, last part, lordship.
Page 46. However, the learned counsel for the parties have moreover, the learned counsel for the parties have also submitted in unison that the which part?
Page 46, last part, lordship. Send back the case record.
That has submitted that the following paragraphs reflecting in CR number 2920 order dated 9/12/2020 in so far as follows, inverted commas mein dekhe likhiye, page 46. Page 46 of more wrong ID kori thuisu, requires to be set aside, full stop. Accordingly, accordingly, it is provided that the said part of the order shall not be acted upon. Shall not be acted upon by the trial court. On a joint prayer made, this petition is closed.
Last part, lordship. Take up 16, lordship. 16.9 to come in. 16.5 and 16.9.
We remember reading it, but we cannot recall it. That has been a bane for me for a long, long time. I read the sentence, I know it is there. I do not remember where did I see it. Thank you. Yes. Where were we at the last tip?
36B1, my lord.
36B1, yes, madam.
Arresting authority signing as a witness under 36B1.
You have to show us that. I think they were arrested. There were two persons authorized
Yes.
and one of them arrested, the others,
And
other was the
this-
witness. Yes.
One, and second, my lord, violation of section 48.
Two issues and we can close this. Please.
I will give their answer
Hmm.
precisely what they said. The person who has put the signature there, he was accompanying the arresting authority. During the relevant time, there was no net and there was a curfew also because
Huh?
of the curfew. Because of the law and order situation, total area is Bandh call is there. And from one militant organization, they have also called for the Bandh and there was burning, rioting and everything to that effect. I have written to my department, they have clarified the issue. This is
So he was arrested amongst the burning and curfew.
because no one could go outside, nobody was there. However, he was arrested there while he was there in the airport.
Airport. So in the
Airport.
airport, there were no police officers, other independent police officers.
Yes, Your Honor. To that effect, I am giving. Looking to his
Presence. Let us call it the presence.
presence, or I don't want to use any
Aura.
other word, or
Yes.
his, nobody is there to come and sign there. Nobody is there to come and sign.
From where do we find that?
And TIP is also there. This is a.
No, that part. From where is he stating all these things?
This I am situation I am showing. This is the press release for that day, 678, and this is the notification which will reveal everything with regard to the law and order situation during the relevant
We
period.
understand everything. That since no one else was present and this person was required to sign. From that document of that day, where do we find it? We will definitely consider this aspect. We are not brushing it aside. We will take this into consideration.
Through HOB plus IO, both the letters are there in the last page I have attached because I have made these queries, and these are the press release given by the head of the branch. CBI arrested Mitai outfit, Arambai Tangle, and because of his arrest, all looting and arson started at that point of time. It is given.
When this man was arrested.
Was arrested on.
No, because of the arrest of this man, everything started.
Prior to that, it was there. Ethnic
Ethnic
it
was there.
It was there, and this constable was already terminated because of his all illegal activities from their department. Thereafter, he was being during the course of investigation, since investigating agency could not able to arrest him, the investigating agency were search of him. And ultimately, he was found over there in the airport. And looking to the situation, they cannot go outside the airport. He has to produce here in the magistrate court in the Guwahati. He has been immediately brought to the Guwahati instead of making any delay and looking to the situation, because their own people, they have come to know that this person is arrested and they started all arsoning there. This is detail given in the press report, if your lordship will permit me.
My lord, I also
For the
will
sake
forward
of
the copy.
state, for the sake of sovereignty, I want to read it.
Copy, my lord. What?
No, this is the press release.
I have to go through, my lord.
This is already there on and this notification is also there. If your lordship will permit me to read it meticulously, then lordship will appreciate the fact, because
First page is
the innocent people and
the first page is regarding the banning of the internet connection. Yes.
and thereafter why it is banned.
When was he arrested? The date?
2025.
And this is 7th June.
8/6.
7 June.
Hmm.
And the ethnic violence was occurred in the 23. Since then, he was being our investigating authority is searching him. And ultimately, right from 23, he was arrested on 7th June 25. It was so difficult to arrest him. 8th June. He was in the surveillance, but it was difficult to arrest him. And ultimately, he was arrested on 7th June. Since 23, he is evading the arrest. I'm going through, your lordship. In view of the prevailing law and order situation in the state of Manipur, especially in Imphal West, East Thombal, Kokokching, and Bishnupur district of Manipur, there is a apprehension that some antisocial element might use social media extensively for transmission of image, hate speech, hate video message, inciting the passion of the public, which might have serious repercussion for the law and order situation in the state of Manipur. And whereas there is an
No, that we have read, that it was, that
now I'm
internet
coming to
ban
the
was
press
imposed.
release. Press release. This is a authentic given to me from the CBI. I will start from the half of the page. The CBI statement made it clear that the Singh was arrested from the Imphal airport on Sunday. As a preventive measure, the administration has issued a prohibitory order in the Imphal West, Imphal East, Thombal, Bishnupur, and Kakching district, while internet and mobile data service, including the VSAT and VPN facility, have been suspended in these
When was he produced at Guwahati?
on the very day on bringing. I will that will be Sunday. He was arrested on Sunday. He was produced. You definitely either on
Definitely no, but there must be something. We will not have a definite.
CD will speak that. CD said.
We are trying to now conclude up the thing before in the next.
Magistrate Kamrup Metro, my lord.
When?
On 8/6/2025.
He was, just a minute. On 7/6.
8/6.
On 7/6/2025, there is an internet ban and everything. Hannah?
Yes.
Internet ban is there. Then on 8/6/2025, what time was he arrested?
My lord, 9:20 AM.
9:20 AM. This is a Sunday, right?
At Imphal Airport.
This is Sunday.
Sunday.
Sunday, है ना?
Yes, Sunday.
Imphal
Saturday is 7/6. I have
Sunday,
written
my lord,
Sunday.
Airport. We are not deciding anything. We are just trying to
I'm
take
just
down
trying to
the
give the figures as asked by your lordship, my lord.
Imphal Airport. At Imphal Airport arrested, है ना? Then when was he produced?
4:30 PM, my lord.
At
Chief Judicial Magistrate Kamrup Metro.
Kamrup
Metro.
Metro. Okay.
And time is
On the same day.
Same day, my lord.
8/6/2025.
8/6/2025.
Okay.
They brought him by flight.
Then from then on, he is behind the bars.
Yes.
है ना? Behind the bars. Now we will just try to note down. Petitioner, you have made two allegations. 30 section notice under.
36B1.
Sorry, 36
B1
B1
and 48.
uh,
Lordship.
yes,
B1 and 48. Now, my lord.
Sorry, signature by
the
one of the IO.
IO.
person arrested, a person authorized
to arrest.
He is, unless he has given.
Accompanying the IO.
It's a wrong submission, my lord.
But I do not want immediate reply. Yesterday also I said this is not Kaun Banega Crorepati, fastest finger first. Nahi chalta hai. You had that piece of, you had given us that piece of paper. We'll confront her with that. We'll confront her with that as and when necessary.
My lord, my lord.
Eto heri korokson. Ekhon bhitor dibo ha. Who signed it, madam? The witness is Manish Kumar.
Please.
Is the witness Manish Kumar or Rajesh Meena?
Rajesh Meena.
Rajesh Meena is the witness.
Witness. As a
Now, your authorization, in view of the above, since the undersigned is camping in.
Kumar was the sub-inspector.
In view of the above, since the undersigned is camping in Kolkata, I hereby authorize Rajesh Meena Sub-Inspector and Manish Kumar Sub-Inspector, both posted at CBI ACB Guwahati, to locate the present whereabout of Kanan Singh and arrest him. So, Rajesh and Manish were both authorized to
this investigation
and
as well as
arrest.
arrest also.
So, the submission of the petitioner that this, one of the witness was, or the witness was also authorized to arrest him is correct. Whether he could have done so or not is another issue that we will adjudicate. But the factually it remains that he had a,
Proves that even if the person is not
True,
authorized,
we'll-
then if some.
that is for adjudication. We are on the fact part of it.
We can
We
answer.
are on the fact part of it. We are only on his submission. Whether he was authorized or not is the only submission he is making that we have to take into consideration. So, yours is 36B1 signed by a person who was authorized to arrest, and the second is 40.
And he 48, my lord. But on 36B1, my also submission also there that he is neither a member of family nor a respectable person. Independent. Independent.
Independence is not there. Independence
witness
of
is written
the
here.
independence of the, huh?
Name and address of the independent witness
Who?
within 17, clause number 17.
Mm.
And within bracket, whether friends, relative or member of the family.
Mm.
It definitely is not the friend, relative or member of the family. As an independent witness, he has given the signature.
Okay. Your submission is that if 36B1 is not followed and there is no respectable person who signed it
Family member, respectable person.
or family member, but we are keeping that apart because no one was there at that point of time. It should have been any other
Respectable person.
independent respectable member is your submission. And your second submission is that 48 notice, someone should have, there should be some indication that it was provided to some family member in some manner where they came to know about the ground of arrest.
My lord, may I add up, my lord?
Hmm.
36
Hmm.
B1, there was a query from the court that
Hmm.
what is the effect of violation of
Hmm,
36 B1.
hmm.
Then lordship, I passed that Kolkata High Court bail order,
Hmm.
my lord. I have a proper answer, my lord. From judgment I'll show, it is very specifically written that if 36 B1 is violated, then it is violation of Article 21 and 22. I have the judgments. As Guwahati High Court judgment I'll show,
Now,
Bombay High Court judgment I'll
there
show.
will be also one thing that this court is going to consider while delivering the judgment is the prevalent circumstances in which everything happened.
That also I'll reply.
The denial of this court cannot shut the eyes that at that point of time, whatever was happening in Manipur, Imphal, other places, was something which was extraordinary as of today's society. In that circumstances, the violation, if any, the preceding part and the immediately succeeding actions taken, would that play any role?
My lord, for that I'll place the judgments as I have said. That violation of Article 21 and 22. Clear violation if 36 B1 is not followed.
Yes, we
And-
totally agree.
And we have to go as per the provisions provided under 36 B1. Who can
Yes.
sign? Nobody other than that. And on that day, my lord, the entire plane, my lord, aeroplane, full of passengers. Airport was busy. Customs people were there at airport. So many officials were there at airport. And airport, my lord, entire airport was open. I have just inquired. It was functioning. There was no bar from getting one independent person. But the thing is that, my lord, I asked my client, he signed it at Guwahati. And actual fact, my lord, I have the video and everything we have, but we cannot show to this court. He was picked up and we have made averment in our bail petition. On 7th evening, he was picked up from a petrol pump. Entire evening, he was kept. Morning, he was brought to Guwahati on 8th. What is coming out from her mouth, submission on 7th, arrested on 7/7, that is correct. That is our averment also in the bail petition. For a moment. That is our averment also. 7th evening picked up,
No.
kept in a secret location, morning brought to Guwahati, early morning, everything signed at Guwahati. That is the reason why they could not serve this 48, 47 odd. And my lord, on 36 B1, my lord, with judgments and all, I'll make submissions, my lord. Violation, everything I will show, my lord. One more disturbing thing, my lord. When I come to 48, my lord, two things. First, they are saying that they have served it through WhatsApp. I will show Supreme Court
latest directions, WhatsApp service is not allowed in cases where it is not allowed. WhatsApp service is not allowed when it has immediate bearing on my liberty. Also, Supreme Court says when the violation of some sections or notice under some sections has got immediate bearing upon my liberty, then it cannot be WhatsApp. One. Second, any notice under chapter 5, like 47, 48, all this has to be as per chapter 6. Why I am saying so, my lord? More disturbing fact have come up in our research yesterday. The 48th notice they have sent by WhatsApp, sent to a minor, 14 years old girl, Lisa, the daughter. They have made statement that notice was served to Lisa. 48 complied. How? Because WhatsApp given to Lisa. Lisa's birth certificate will produce. We'll give them a copy also if they want to verify. She is 14 years, my lord. Service to a minor is no service. And anything which we have to serve to a minor has to be served to a legal guardian. And my lord, in support of that, my lord, I will make my argument, my lord, from section 66 of BNSS under chapter 6, which says that any service of notice has to be on adult male member. I will argue on section 153, 1 small a of Customs Act 1962. It says service has to be on adult member. Even CPC, my lord, this is a criminal case, I understand. CPC Order 5 Rule 15 says it has to be an adult male member. Now, my lord, this cannot be allowed. So, my lord, here 36B1, they have made a complete mockery when the arresting authority signs. 48 also, my lord, how can a minor be allowed? What she knows? Even if admitting for this sake of argument that is served it by WhatsApp, even if saying that it is allowed, minor, that cannot be, my lord. 14 years minor cannot be. Tomorrow they will serve it to 8 years minor. Minor cannot be. And for that, my lord, precedent has to be set, my lord. On these 2 points, my lord, these 2 are gray areas, my lord. One, this arresting authority signing. And second, notice 48 notice is served to the minor, my lord. These 2 are gray areas in this case. And with regard to 48, when I am saying that all service or under section 48 should be as per chapter 6, this is also a half-baked, because what judgments I will place is with regard to 35. Coupled with the fact that Supreme Court says that if it is a question on my liberty, then chapter 6 has to be followed. So, since for 47, 48, all this come under same chapter. So, this also has to be, 48 also has to be as per chapter 6. If Lordship allow me, I will take your Lordship through one by one, my lord.
But we will not go through the entire this thing.
No facts, my lord, only
Just
law.
go through the relevant portion of
My
it.
lord, I am just making a submission. My lord, if Lordship is convinced on 36B1 and 48, I wanted to argue on 47 also. I also wanted to argue that there is no chance of conviction. All this I am keeping reserved, my lord. I will not argue. Today I'll argue only on 36B1 and 48. If Lordship is satisfied, then we'll not go into all this, my lord.
Yes, we can
Yes.
try that.
Yeah. Guwahati High Court to dia. মোক হেৰিটো দিয়াচোন, এইটো প্ৰিণ্টিংটো দিয়া না আমাৰ। গুৱাহাটী হাইকোৰ্ট দিয়া আৰু দিয়াচোন। Lordship may kindly, this is our High Court judgment. But it is 41B, I think. There are 29 and 30, my lord.
Pera?
29 and 30. May I read, my lord? As far as the submission that there is a violation of section 41B, B1 of CRPC in arresting the accused applicant is concerned, this court has perused the arrest memo given to the accused applicant while she was being arrested. It is found that there is no attesting signature of any member of the family of the accused applicant or of any respectable member of the locality where the arrest was made, directly matching with our facts. Para 30, in the case of DK Basu versus State of West Bengal, it has been clearly provided that it is desirable that the officer arresting the person should prepare a memo of arrest at the time of arrest in the presence of at least one witness who may be a member of family of the arrestee or a respectable person of the locality where the arrest is made. Therefore, it is seen that the mandates of the principle provided in the case of DK Vasu, which has flown from Article 21 and 22.1 of the Constitution of India, is to be strictly followed. However, in the instant case, apparently the provisions under Section 41(b)(1) have been completely violated, thereby depriving the accused applicant of her fundamental rights guaranteed under Article 21 and 22(1) of the Constitution of India. So this was the query from the court. Answer is this, my lord. Effect. This is the proper answer. Now, Bombay High Court, I will place, my lord. View taken by Bombay High Court, para 12. Paragraph 12, my lord. I read, my 12. This court is considering the present matter only to consider the act of the respondents of illegal detention of two petitioners. The provisions of Article 21 and 22(1) of Constitution of India show the fundamental rights of the persons like petitioners. The safeguards needs to be provided for compliance of Article 21 and 22 of Constitution of India against the arbitrary arrest and detention. It needs to be presumed that aforesaid amended provisions of CRPC like Section 436, 41A and 41B are to comply the mandate of Article 21 and 22 of the Constitution. Section 4. So, my lord, this Bombay High Court also says this fundamental right. And my lord, yes, on the last occasion we have placed one judgment from Kolkata High Court where due to violation bail was granted. Now, lordship, we have another 7 judgments. There are numerous. Kolkata High Court, my lord, is taking, if there is violation of this section, directly bail, my lord. On one ground. On this whole ground of 36(b)(1) bail has been granted. If required, lordship, we can just place the judgments and not read.
Give us a list.
Place the bunch. This is the bunch, my lord, I am just providing all on similar, my lord, 36(b)(1) violation. And one judgment on the last occasion I have given.
You will have to resubmit that Kolkata one.
My lord, yes.
This is Kolkata 2023, this one.
There are 6 judgments are there, no? 6 are here, one I have submitted on the last occasion. My lord, we'll make a 6 are here on one last occasion, 7 bails on only on this sole ground. And why? Because it violates Article 21 and 22, and that is, my lord, I have shown from Guwahati High Court judgment and Bombay High Court observations, my lord. Now, my lord, what point I am keeping, my lord, for adjudication of this court is that my submission, my lord, is directly on the point that I am saying that one person cannot play 2 roles. When there is arrest, there are 2 roles, one arresting authority and one accused, one witness, and in the middle is the accused. This arresting officer, he will come and say, yes, I am the person authorized to arrest you. See, this is the authorization I got from my superior. We are arresting you now. And at the same time, he goes the other side and he says, yes, I'll be your witness as family, member of family, friend, relative. So, my lord, one person cannot play 2 roles. So, my lord, this we keep up before this court, my lord, bring up before this court for adjudication. And my lord, this is a gray area. We have made extensive research. Nowhere we have found that a police officer or any of members from the raiding party signing an arrest memo under 36(b)(1) or older 41(b). No, there is no such case laws we have found. So, lordship, it is my humble prayer that if lordship is satisfied with my reasoning and my submission that this cannot be, because this will violate the fundamental right, then lordship may kindly set the precedent that at least whoever may sign, there is no problem with that, because on last occasion lordship also had put a query that if it is a lonely road, what will happen? Now, my lord, what happens? Police finds a person on actual fact, I will say, my lord. Police finds a person on a lonely road. They don't serve arrest memo there, my lord. They take your arrest memo, come with us. No, they will pick him up, take to the police station and then interrogate. After interrogation, if police deems it fit that he needs to be arrested, then arrest memo is given. Now, my lord, the law is a police can pick up a person for interrogation. Now, in this case, if we come and say that we were picked up in the evening of 7/6 and we were produced before the magistrate only or at 4:30 of 8/6, after 24 hours, we cannot take that ground. Because if today we take that ground, then CBI will say, no, we just picked you up for interrogation. We interrogated you entire night. And then we thought at 9:20 AM, we thought that your arrest is necessary. So we arrested you at 9:20 and then we produced you before the magistrate within 24 hours.
That has been set aside by the court. The court has already set that ground aside. The moment there is an admission that we have picked you up at so and so hours, 24 starts then.
Is there, my lord?
Starts from detention.
Now, my lord, when police went there, my lord, entire team was there. It could have been anyone, any Havildar also, my lord. If the PSO of the IOs, then he could have signed. We could have said that yes, he's independent. One person who has his name on the authority letter can never be independent. So, my lord, we want this precedent also to be set if Lordship is satisfied with our reasoning and argument that let anybody sign, but one person may not play two roles. One, he will be a person authorized to arrest, and another, he will be a witness. Dual role may kindly not be allowed. That precedent we are praying to be set down, my lord. And this is a grey area.
Why do we need that witness to the arrest?
My lord?
Why do we need a witness to be to the arrest?
Why do we need a witness?
Why does the law require there to be a witness to the arrest?
Witness to the arrest. Otherwise, that's why, my lord, habeas corpus.
Because if we say that it is for the purposes of informing the family, informing the relative, informing the friend, informing whosoever it is, that is already played. That role is played by the notice under 48. So a witness at the time of the arrest has to have some importance.
The importance is that, my lord, I have not got the judgments, but while doing the research, I have come across this. The reasonings by the Supreme Court, my lord, or in some courts I have found, it is that if a person is dislocated from a place, there has to be a person who says that yes, he is taken by the police.
It was done with the authority of
Yes,
law.
police took him. So one person has to stay back there to inform the family members. Otherwise, police will go. They will pick up anybody and then family will come with habeas corpus petition. That is the reason, my lord, that one independent person or family member or someone may be present. Otherwise, court has judgment to assign again. DK Basu, I am reading, my lord, para 34. In addition to the statutory and constitutional requirement to which we have made a reference, we are of the view that it would be useful and effective to structure appropriate machinery for contemporaneous
that paragraph sort of introduced the provisions of 36(1) that someone should be a witness to the arrest.
To bring transparency and accountability. These two words have been used. That's why, and my lord, this is a mandatory provision. And if it is not followed, then it is violation of fundamental rights. And where there is a violation of fundamental rights, arrest becomes illegal. And if arrest is illegal, my lord, accused is entitled to bail. And my lord, they have now, lordship, may I come to 48 now? 36, this much only, my lord. I have shown for 36, I have shown, my lord, how non-compliance is violation of fundamental right, I have shown.
48, all arguments of the CBI being accepted for the sake of it. Even then, service of notice on a minor will not suffice.
Will not suffice, my lord. And for that, my lord, what I have prepared is that I have prepared that any notice under chapter 5 has to be under chapter 6. I'll make that argument. And my lord, I will give Delhi High Court, my lord, judgment is there. Then one notification is there, order is there from the Delhi police. And then Supreme Court order is there, my lord, approving all this, my lord. First of all, birth certificate from different place. Lordship, I am just placing birth certificate before Lordship, and I'll also giving a copy to the CBI, my lord. If they want, they can verify from the authorities. And in case, Lordship, later they find someday that this is fake, they may come and inform the court. This is the birth certificate. She was 14 years, my lord. Lisa.
Okay.
And my lord, Juvenile Justice Care and Protection Act says police officer cannot go to the go before a child with uniform, bats, etc. So much protection is given. And my lord, these police officers, they will inform the minor about arrest of father. What will be the mental condition of the minors if this is allowed, my lord?
She is the daughter or niece.
Daughter. She is the daughter of this.
Where is their statement that this Lisa was informed? Yes,
Yes.
we also remember reading. it.
Page 111. Asane, right?
There is in fact given by
Constable, let's go to-
accused himself.
Kindly see, my lord, page 111 and also remand order also. Remand order there. Page 111, my lord. At the top, they have made the note. Remand order say to diya na.
This we have taken in
My lord.
our objection also.
Chief has
You've named the lady, na?
Right.
You have named the receiver.
First, we have tried to contact Y.
Hmm.
When her mobile phone was switched off,
Ah.
then we have accused has given this number and we contacted. And
But-
that person has come yesterday from the HOB and from this page 8 I have already given, which has been written to me for the clarification I have asked for. It is submitted that the accused applicant himself provided the mobile number so and so belonging to his wife, me Boli Devi, to the arresting officer, and accordingly when contacted this number was found switched off. Thereafter, the accused applicant provided the number so and so belonging to his friend Chingi Thang Nambam, and accordingly his friend was informed about the arrest of the accused applicant at the time of arrest.
My reply, my lord, would be whatever may be the circumstances, whatever, my lord, under no circumstances, service upon a minor. Whatever may be the circumstances.
They sending it to a phone number which you had provided. Cannot be taken to be wrong. But when this court comes to the has the knowledge that it was served upon a minor, will it suffice 48 is what we will see. We will not take it to be their intent to serve a minor.
Yes. I understand.
They were given a number, they serve it. Did they fail in their duty to find out whether the daughter is a major or not?
Yes, my lord. That is my submission, my lord. My lord, if lordship is satisfied on that point, law has to be set down on that point that you verify the person whom we are giving daughter, if she is a daughter, what is the age? And my lord, Lisa's name, lordship will find also in the remand order, which I have certified copy already I have given. There also it is written the grounds of arrest has been communicated to the accused person by serving notice under section 47 of the BNSS, and his daughter, namely Lisa, has also been informed by serving notice under section 48 of BNSS as mentioned above. So it's Lisa, my lord.
This has also been served to the Babita, who is sister of
And-
the accused applicant.
Sorry?
It has also been information has also been given to Babita, sister of accused applicant. We have given in page number 8 today, we have
The
provided.
very manner in which you withdraw the word notice and you introduce the word information,
Yes.
it crumbles the entire confidence this court is trying to build. When they want, when the respondents want to substitute the word notice by information, that crumbles the whole confidence. The respondents' assertion, if they had asserted that this information is notice enough, we could not have done more, then the line between a notice and an information thins out.
It's a very
But the moment you say that the notice information was given, that very moment we notice that the notice is not there. That becomes difficult.
entire scenario during the relevant time. As my learned friend said, that even in the flight, we could have taken the signature of any independent witness.
That is
Does
not
it
my,
viable?
no, that is
Any
not my
particular
submission.
case?
That is not my submission.
And another submission, it was full of passengers and airport is full. At that point of time, everything is closed. Bandh was prevailing from last 7 days. None of the person was there. And after 2 years, this person is apprehended. And very much influential person there. Everybody knows his name. Nobody will turn up.
My lord, if arguments are being made on facts, my lord, merits, my lord, I have reserved that argument. My arguments, my lord, I have reserved on the merits. We are only on law point, my lord. That whether followed or not followed, whether needs to be followed or need not be followed. Whether mandatory or not mandatory.
To that effect, I will show your lordship Supreme Court judgment. I have also judgment. Not of the High Court, of course, the Supreme Court, of the division bench.
So,
My lord, now, my lord, I am pressing on the point that notice cannot be served. Notice under section 48 cannot be served to a minor. I am making submission on that point only, my lord. Now, my lord, now suppose today this is taken, because I have raised an issue, my lord, now that this notice served to a minor is illegal, non-est in the eye of law. So since I raised an issue, my lord,
the only thing that troubles us all the time when we are going through these kind of cases, we are discussing because so that you can have we can have your views on that also.
my lord,
On a number provided or nominate on a person nominated by, no one comes up to make a statement that this is the person I had nominated, and it was not informed to him, but rather they found out that person and informed it to him. Now, the mobile number of the daughter did not come up in the air. There must have been some reference by someone that this is the number. Send it to him, someone in the family gets it. I don't know who it is, but someone in the... From where did that number come? If the number is provided by the father, assuming, allowing the notice to be sent to the daughter, can we accept now when the petitioner comes up to say that this is the minor? My phone number might be in my daughter's name with the Aadhaar card. She might be a minor. She might be using my major's phone number, but it is with my minor daughter.
yes. That's why
So that whether it was sent to the minor, there is no assertion from the petitioner as of now saying that this is not a number I provided. These are the numbers I provided. They were active and the notice did not go there. No attempts have been made to that. Specific affirmance that the number given was of the wife is switched off. What more?
That's why, my lord, Supreme Court, my lord, says. That's why Supreme Court says that this type of notices not allowed through WhatsApp.
True. So so what you would want us to conclude is, once that phone number is given, the person is at an unreachable place where the arresting authority cannot go because of whatever conditions. The 48 hours, the 24 hours will pass, the 2 hours before production, before magistrate pass, everything happens. Traveling time is more than that to the place of a place where the person wants the notice to be served. It will take more than 22 hours. Therefore, bringing down the 2 hours will be also violated even if I make a move now. The notice cannot be served during that. What happens?
My lord. There may be, my lord.
I have come through a case where the person is from Chittoor. Sitting here, he says, go there. The arresting person, he investigates or he runs around with a notice to Chittoor.
No, my lord.
in this regard, my lord, there may be many situations, my lord. Let me constrain myself to my facts, my lord.
We are trying to do that only.
I am from Manipur.
Ah,
You have arrested me from Manipur airport. You are not calling any family member or relative or friend at Manipur. And you brought me.
Where is that nomination? Call him. Where is that?
My lord, there is no form for such nomination.
The provision of law which we have been trying to go through says that person nominated. We do not understand what is that nomination. None of the petitioners try to explain us what is a nomination. Today you have asked me a question, where is that form? I don't know where is that form. That is why we are putting that question.
My lord.
If you have 48 for a moment. Have
48,
for a
my lord,
moment.
I am also taking out.
Yes, have 48 for a moment.
48.
ইখন ক'ত গ'ল? Thank you. 48.
Should be relative, friend, or such other person as may be disclosed
Or nominated.
or nominated
Now,
by the.
now I nominate my minor son. I don't tell it's a minor. I nominate him. Message has to be sent. Because someone if I'm arrested in Orissa or if I'm arrested in Karnataka, they don't know whom I have at home. May not know. So I'll nominate one. That nomination has to be verbal on the spot. I will not be signing anything. I don't know how to read and write. Fine. They're asking me Hindi. I said Kannada, please. Give me Kannada. I don't know. Everything is in a soup now. I just have to delay it for the next 24 hours. Everything goes.
Yes, I get it.
Can that be the intent of the orders of the Honorable Supreme Court? Cannot be. It has to be a situation where we can find out that yes, this is the maximum limit. Or no, this has to be an exception. Somewhere something has to come in. The law that you are placing before us is a law which is going around. Here is a situation where the respondents are trying to say, look at the situation. We cannot move. Their assertion. We cannot move. We are having a person in our hand who is if we may use the term, it's hot cake. Anybody will try to take him away from us. It's precious now. We are two persons standing on two sides of him. One will not be enough. We need to complete the formalities. We do it with honesty. We do it with integrity. May not be sufficient according to the law. We do the best we could. We brought him back to here. Flight hour, up and down, traveling time, everything taken together. By 2:30, we were at the airport. By 4:30, he's before the magistrate. Before the magistrate, these are the statements made. Because now we have again seen from this thing. Now that is what we will look into in the trial court record also. He gave the phone number before the magistrate. If that be so, man is giving a number. Where else to send it? I'll have to drop him here and I'll have to go back. Can that be the intent of what's... When we talk of Article 20, when we talk of right to life, liberty, whatever, Supreme Court recognizes that there has to be a certain extent that you can go to. You can do it in accordance with law. Is it only with accordance with law? Or does the doctrine of necessity flow in? At times. Will it flow in? Has it to be taken into consideration or no? It has to be Patthar ka lakir. You cannot, it has to go. Then it will be a weapon. It will be a weapon where the trigger is with the person who is violating the law, who is alleged to be violating the law. And it be stretched to that extent. That is a debate whose arguments we are not finding anywhere. This is a question which for the last 2-3 weeks I have been trying to put down to everybody. What is this nomination? How do we take that nomination? Whom to believe? Just because a man's liberty is being questioned, are we to question the very integrity of the officers who are certified, who have certified integrity everywhere? Every of the service records will say he's an integrity, man with integrity. He's given a job to protect the country, the peace, the quiet of the country, and then we say no. कुछ तो बदमाशी है. Machinery function then. If we go by such strict interpretations, as lawyers, one would do his duty. As a defender, she would do her duty. As a court of law, I would be interpreting. Assisting the society? Or are we inside closed doors debating? That has to be a question. Because this what I find, with all due respect to every judgment I have gone through, my sincerest respect to each of them, exceptions are not being considered anywhere. 20:1, no question about it. It is the final right a man has. Any citizen, any living being has the right to life. It belongs to everybody. We just say that, okay, this sentence, therefore this goes. It be so.
My lord, situations may be different with regard to different facts, my lord. So, my lord, if we constrain ourselves to the facts.
We are trying to concentrate here. We are not speaking out of the context for a moment, sir. A situation where 2 persons have gone to the airport. A situation where everything is burning outside. A situation where the man is picked up, brought back immediately to Guwahati.
On 8/6, there was peace, my lord. No media report, lordship will find nothing.
Very well.
On 8/6, everything is...
with everything done, they bring him back, they produce him before the magistrate. What does the magistrate record? No problems. One judicial officer records. Nothing wrong. We are remanding him. Right? So, are we to say that the judicial officer overlooked everything? We cannot. Then the assertion is that the phone number, where does it come from? Your assertion, I was deprived of every assistance I could have. That means you were alone. From where were the numbers produced? From where did the names come? From the source? Who is the source? Now, someone standing up to say that this is all wrong.
May I make this submission now? Kindly see one thing. It is their report, my lord. They say that first number what I gave was of wives. But one club secretary. One daughter.
And someone gave the phone to the sister.
And from my end, whatever I could, I have given.
Yes.
If in such situations, my lord, rather than...
They should have let you go. They should have let you go. They should have traced out the entire family tree.
No.
Then they should have come back to arrest you. Is that the argument?
My mobile phone was with them. According to them, they seized 2 mobile phones from me. That is on record, my lord. See that?
I can give you my mobile phone, sir. You will not be able to open it. For at least the next 24 hours, you will not be able to open it.
My lord, when suppose an arrest is made in such cases, my lord, a person gives his wife's mobile number, club secretary's mobile number. Now, club secretary was a major. And club secretary could also have been furnished. So, let me check for that, my lord, first of all. Friends, yes, friends is there. They did not make any endeavor to find out what is the age of the daughter. They could have asked him, what is the age of your daughter? Then 48,
it would not serve any purpose giving it to the club secretary, because knowing that the person is under arrest, knowing that this man has been arrested, knowing that the minor daughter has been given a notice, nothing was done for the last 2-3 months. So he is not a friend.
I did not get, sorry.
When the club secretary knows, he was told, the club secretary was told,
yes,
this man has been arrested.
On the day of arrest.
Yes.
According to them, my lord.
Told, no movement. He's not a friend.
No movement means, lordship, he was informed.
The moment he's informed, he's a friend.
Means I'm sorry, my lord.
When the club secretary knows about it, his friend knows about it.
Yes. But when call was allegedly made by the CBI, he came to know, suppose. Yes.
Then what remains? Then what further remains for the notice?
48, my lord, it has to be in writing. As simple as that, my lord.
That is what I'm saying. This man should have been let go. They should have
Not
made
let
out
go,
that
my lord.
notice in writing, kept it ready. One man at the club notice, club secretary, other person arresting him, giving him the copy.
Suppose, sir,
That is the only solution.
No, my lord. With all respect, my lord. In such cases, my lord, if service by WhatsApp is allowed,
No, we are not on the WhatsApp part. We want the service to be made in writing, originals to be submitted
yes,
to a person in Manipur
Yes.
when the arrest is being made in Guwahati within the next 24 hours. Tell us how.
yes. I am on the point, my lord, that I have provided 3 numbers, my lord. 2 major, 1 minor.
All in Manipur.
All in Manipur. my lord.
Huh.
Now,
WhatsApp
one
not
major,
being allowed.
suppose for a moment, let us say WhatsApp is allowed.
No, let us not have it allowed. Let us come to a solution. WhatsApp is not allowed. How to solve?
If WhatsApp is not allowed, my lord, then there is a problem, my lord. I understand that. Suppose a person is being held here, no friend, no relative, none. Then it has to be under chapter 6. Chapter 6, my lord, of the, let us see chapter 6. Chapter 6 of BNSS will also do, my lord.
Anything, you take up anything.
Or CRPC, my lord, same, my lord, chapter 6 only there.
Which part?
Chapter 6 only, sir. अपने BNSS रहते हैं.
This has to be probed laid down when the situation becomes impossible. What to do?
My lord, can we find an answer here? Let us see, my lord.
Yes.
Chapter 6 to light, na? Yes, sir.
I like it a request list. No, 2 minutes. Huh? Yes, madam, it is not, these questions are not only to the petitioners. It will also, we would also require your assistance on it. It's not as of now. We'll go one by one, otherwise we get confused up.
That he can raise his objection at the magistrate court. He never raised any prejudice.
That will come later on. Those arguments will all come later on, not to worry. But what we want to find out is, how were you supposed to serve it in this situation? We are asking him for a solution. Let us see how it can be done. Bodies, procedure and service cannot be affected as before provided.
That's it, para 12 to some key question. My lord, I am reading para 12 of one judgment, my lord. My lord, this judgment is approved by the Supreme Court. It's Satyendra Kumar until, my lord. Para 12, the learned counsel for a respondent submits that efforts were made to intimate the petitioner, including messages through WhatsApp, email, and a visit to the residence of the petitioner office need to join investigations and to appear before the investigating officer. If the officer visited the petitioner's residence and did not find him there, surely the IO could have pasted the requisite notice under
So this man goes to paste it in Manipur.
They have their branch, CBI branch at Manipur.
It is during normal.
Then why a person has to go from here and arrest? He could have been arrested and produced there.
It is under normal situation.
In this situation, everything has been transferred, and even the courts in Guwahati, if we are not wrong, were allowed video conferencing for the investigation. Is it the same case? Does it relate to the same case, madam? That video conferencing by investigation by video conferencing, that notification being there, Supreme Court sending everything to Guwahati. It had to be done through Guwahati. These are facts we must know before we touch this case. Now, if you have 69, kindly have 69. When a court desires that a summons issued by it shall be served at any place outside the local jurisdiction. Let us say this is a notice which is being sought to be served outside the jurisdiction of the particular arresting authority. Shall ordinarily send such summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or is to be there served. Meaning, in another case, what the CBI or the customs had done is, they sent it to their head office at the other state. That person was required to have it served as soon as possible. They made the arrangements. They reported within half an hour that, look, this address, no one lives here. It has been under lock and key for the last so and so time. that message was got back. Or we have served, this is a signature, keep it for your records. Some procedure to be done. Is it not? So WhatsApp is what? There are nowadays where I may be carrying the phone number, you may be carrying my WhatsApp.
Yes.
Is it not? You can have it on a different, in such a situation, WhatsApp may not be the right mode of communication. We agree to it. Here the situation is totally different. The person has been brought back. Within hours produced. Now the question of 36 and 48. When people are not within the jurisdiction, argue on that. You have asked us to lay down the law. Assist us to lay down the law.
Yes, my lord.
Or we will also try to find out a way where laid down law will be taken into account and no law will be laid.
Yes, I understand. Now, my lord.
Is it not? So now we have to close it for today. It is 4:35. We'll have to close it for today.
Before I will end up the matter, chapter 6 is for the regular cases for appearance of a person. How to serve the summon. That procedure.
Look before you leave.
This circumstance.
Look before you leave. This is helping you.
Yes, that is.
So don't run away from it. It might help you.
On the last occasions, they were asked to produce the WhatsApp.
So what? No, that they have done. That they have done. That they have given us.
Also get a copy, my lord.
Yes, why not give a copy of the?
Given to me, Lord.
No, not that part. You have your instructions from the officer. All this.
Ask for this thing.
No. What we are saying is.
This one. They have provided me.
If you see this.
Daughter's.
The phone number.
7005115.
515 number. Last number is 15.
That is supposedly the.
In violation, my lord. Not before 2 hours. Kindly see the time 3:20.
We agree to everything of it. We agree to the time is.
This cannot be 4:19 and 4.
The specific statement is that the phone number was given in the presence of the magistrate. So therefore, we are talking of handling circumstances where the person presume, even if the court has to presume that the person is not giving the details, is not nominating someone, is not doing anything, then how do we say that even then 36, 48, this manner, not done, gone.
Okay.
That solution has to come.
Yes.
Because the situation is what? Do the lawyers are conversant with the law? Criminals are more conversant with it. We know how to apply it. They know how to escape it. Is it not? If we are shutting doors, if we are trying to shut doors, if we are trying to enforce, then at least to some extent we'll have to make an attempt that it applies to every situation, not only to the situation that we can conceive of. Then it would be a good law which would go up from here,
Yes.
get a ratification, and you can then probably say we had a law laid down.
Yes. I'll try, my lord. Now, Lordship has put all these points, my lord. So
These are things which are disturbing us from the day we have started looking into 48 and 36 with the intent of adjudicating upon it. So far as we were trying to utilize it, everything was happy. Adjudicating upon it is creating some. But now, if you want this court to continue with the matter, probably not before 19th or something. Otherwise, there is only 1 week in between.
Last day, my lord. Lordship, otherwise.
Tomorrow we are not taking an attempt.
Yes. Otherwise, which date, my lord, is available?
It has to be after 19th, provided we are there, if it is to be before us. And if it is, if you now have all the questions, you can answer any day.
Lordship, I would pray, my lord, 19th, my. Because, my lord, I would like to have it on 5th or 6th, if possible.
5th or 6th, there are a lot of administrative things for which 5th and 6th 6th, we are nowhere to be seen.
Early date, my lord, then 19th.
Not before 19th. We cannot give you a date before 19th.
19th, my lord.
19th, it reopens.
My lord, 26th, I don't know.
21st. 21st is a Wednesday.
21st, my lord.
22nd is a Thursday. Lesser number of cases. So hearing the 22nd.
22nd.
Questions we have put up.
Yes, my lord.
Answers if forthcoming. Because we cannot have a situation where we just read one sentence and we say that it is all wrong. We are not being able to convince ourselves
We
to
got
stop.
everything, lord. That questions, my lord, is now, I'm also considering those questions.
It has
Let
to
me
be.
see if that can be answered.
Thank you.
Obliged.
Part had kori 20.
এটা পাঠাট করিলে নাকি বাৰু কৰিছো প্রস্থান না থাকলে দিগদার হবে কিন্তু
টাইমে ডেট সাপ্লাই সারে দিছে
অবস্থা থেকে
নেক্সট উইকত না থাকে
হলে ভালোই নাহলে টাইম বহুত যায়
এই টাইম আমি রেডি করে বলছি চলে এই দেখবে ঠিক আছে
Itu otak dalam sebelum tapi betul.
अच्छा बोल क्या